We can start.
Should I begin?
Yes.
Principal, sir?
Yes, sir. Yes, sir. Please.
Okay, thank you very much. Good morning to one and all. On behalf of Deccan Education Society's Kirti M. Dungarsi College and Research Promotion Committee and Internal Quality Assurance Cell, I extend a warm welcome to each one of you present here for this national webinar on intellectual property rights, what researchers need to know. Respected Chair, Principal Dr. D.V. Pawar, Honorable Resource Persons for today's national webinar, Dr. Mridula Bele, Associate Professor, College of Pharmacy, Nasik, Dr. Niranjan Yevule, Scientist, IP Group, NCL Innovations, Ms. Nupur Goyal, Associate IPR Scientist under WOC C category of DST, TIFAC, Coordinator, Internal Quality Assurance Cell, Professor Matthew Samuel, Vice Principal and Coordinator, Research Promotion Committee, Dr. Seema Sapde, Vice Principal, Dr. R.B. Kaude, Vice Principal and Life Member, Deccan Education Society, Dr. Meenal Mapuskar, Vice Principal and Prabandhak, Deccan Education Society, Professor V.S. Sontakke, Convener of this national webinar, Dr. J.R. Mahajan, Organizing Secretary, Dr. Subhas Donde, all honorable members of IQAC and Research Promotion Committee, Organizing Committee, faculty of Kirti College, teachers, researchers, student participants from different parts of the country. Friends, intellectual property rights covers areas like patents, copyright, industrial design, and whatnot. Though copyrights and patents were there in 16th and 17th century, but intellectual property rights became a buzzword in 1986 onward, when intellectual property rights were discussed at length among the members of General Agreement on Tariff and Trade, GATT, in 1986. So from 1986 to 1994, there were many contentious issues on which member countries agreed upon, and then came the World Trade Organization in 1995 with one of the important agreement as trade-related intellectual property rights. Let me give you a hypothetical example. Suppose the scientific community in United States innovate what you call radio or a transistor for the first time. You can hear the President of United States speaking in Washington, somewhere in Denver or California. It was nothing less than a miracle. The news spreads to Europe. People in US and Europe start buying those products called transistor, which were huge in size, not portable. The news comes across to the eastern part of the world. Japan also buys it. But the scientific community in Japan tries to open the nut bolt, and then they modify the product. The modified product becomes a portable product, a small transistor which you can carry in your pocket with better quality and at a very, very low price. Ultimately, people in US buy radio or transistor all the way from Japan. So the scientific community that invested many billions of dollars, energy, patience, they get nothing, because the commercial exploitation of that product is by Japanese companies now. So this was a hypothetical example to tell you how intellectual property rights are significant. So in this, with this backdrop, it is pertinent to dwell upon the insights of intellectual property rights. And I'm very sure with the kind of resource person we have, there is someone from advocacy group, advocate is there, scientist is there, then we have a person working in the field of pharmacy. So this is the apt platform to discuss the nitty-gritty of intellectual property rights. But before we move forward, I request our respected principal, Dr. D.V. Pawar sir, to kindly address the audience. Over to you, Pawar sir.
Thank you, sir. Namaskar and good morning to one and all. A very warm welcome to all the dignitaries present over here for this national webinar. Let me firstly thanks to all for sparing your valuable time and accepting our invitation to grace this occasion. I would like to give a brief information about our Deccan Education Society. The Deccan Education Society is one of the oldest and renowned educational institutions in India, with over 137 years of dedicated service to the nation in the field of education. Deccan Education Society was founded in 1884 by eminent national personalities like Lokmanya Tilak and Gopal Ganesh Agarkar. The Deccan Education Society at present has 59 educational institutions from pre-primary stage to post-graduation and research levels in arts, science, commerce, management, nursing, physiotherapy, etc. Our alumni includes intellectuals, industrialists, politicians, defense personnel, literatures, and sports persons of highest caliber who have rendered valuable service to the nation. Ladies and gentlemen, Kirti College was set up in 1954 to impart higher education to the first generation learners of surrounding areas. Currently, along with undergraduate programs in arts, science, and commerce, our college also offers self-finance programs in IT, computer science, BMM, BAP, BMS, and biotech. We have postgraduate programs in English, economics, political science, chemistry, zoology, computer science, and information technology. Besides, we have PhD Research Center for Chemistry and Zoology. I would like to inform you all that our college has been accredited with A grade by NAC in last 3 cycles and has been awarded with the Best College Award by University of Mumbai. Our college is also known for its excellence in the field of sports, NCC, NSS, and cultural activities. Friends, today's national webinar is organized by IQAC and Research Promotion Committee on IPR, that is intellectual property rights. What researcher needs to know? The goal of the webinar is to create awareness among researchers from the earlier belief, publish and perish, to the recent awakening, patent and prosper. There is an urgent need today to strike a balance between individual intellectual property and public interest globally. This national webinar process to provide a forum to understand various facts of intellectual property right, covering patents, copyrights, trademarks, industrial designs, traditional knowledge, their application, procedure, along with the benefits and complexities. Intellectual property right is the gateway to foster greater creativity and innovation in all academic and research institutions. There are 3 technical sessions. First is IPR for academic researcher. Second is research and patenting. And third, trademark and geographical indicator. I wish all the sessions to be more interactive, and I'm confident that everybody will be benefited in solving their queries in their minds. I congratulate to IQAC and Research Promotion Committee for planning and organizing this national level webinar on intellectual property right. I also thanks to research person and participants for their presence. Once again, on behalf of Kirti College and my own behalf, I welcome you all. Thank you, and over to Chandramohan Joshi. Thank you.
Thank you, sir. Thank you very much for this welcome address. Now, may I call upon convener of this national webinar, Dr. J.R. Mahajan, sir, with the concept note. Over to you, Mahajan, sir.
Thank you, sir. Good morning, respected Principal Dr. D.V. Pawar, Vice Principals of our college, resource persons, dignitaries, and participants. On behalf of Organizing Committee of Research Promotion Committee and Internal Quality Assurance Cell of our college, it's my great pleasure to brief this August gathering of today's national webinar on intellectual property right, what researchers need to know. The goal of the webinar is to create awareness among researchers from the earlier belief, that is, as our principal said, publish and perish, to the recent awakening, patent and prosper. So, it is an urgent need today to strike a balance between intellectual property and public interest globally. This national webinar proposes to provide a forum to understand various facets of IPR, such as patent, copyrights, trademark, industrial design, and traditional knowledge, their application procedure, along with benefits of complexities. IPR is the gateway to foster greater creativity and innovation in all academic and research institutes. So in this webinar, there are 3 sessions. First session highlighted about the IPR for academic researcher. Second session is research and patenting, and third session is on trademark and geographical indicator. I wish all the sessions to be more interactive, and I am confident that everybody will be benefited in solving the queries in their minds. I ensure you will enjoy all the technical sessions. After every session now, there will be question answer session. You can ask your queries in chat box. Our team will scrutinize and consider for the discussion. Thank you very much. Over to Joshi, sir.
Thank you, sir. Thank you very much. May I now call upon a member of IQAC, Dr. Jyoti Munde Madam, to introduce our first speaker of the day, Dr. Professor Mrudula Bele. Over to you, Jyoti Madam.
Am I audible, sir?
Yes, Madam, you are.
Okay. Respected dignitaries, delegates, professors, researchers, and all inquisitive minds on this virtual platform, good morning all. The first page of this academic deliberation, titled IPR for Academic Researchers, will be opened by Dr. Mrudula Bele, and I feel extremely privileged to introduce her to you. Respected Dr. Mrudula Bele has a very diverse and bright academic career. Diverse as she is graduate, postgraduate, and doctorate in pharmacy, alongside LLB from Pune University and LLM in IP law from University of Turin, Italy. Her keen interest in intellectual property rights and regulatory affairs for pharmaceuticals has prompted her to complete the postgraduate diploma in patents law from Nalasar University of Law. Her bright academic career is evident with the fact that she is recipient of full fellowship from World Intellectual Property Organization, WIPO, a 1-year Master of Law, that is LLM in Intellectual Property course, jointly conducted by WIPO and University of Turin, Italy. The fellowship, this is the very noted fact when we must acknowledge, the fellowship is given every year to 11 teachers of intellectual property law, and she was the only Indian recipient of this fellowship in the year 2012-13. The course was fully funded by WIPO, amounting to around 30,000 euros. She has attended 15 days training in Tokyo twice on Japanese patent law, and the training was fully funded by Japanese Patent Office and WIPO. Currently, Madam is working as an associate professor at ND MVP's College of Pharmacy, Nasik. Along with teaching co-pharmaceutical science subject, she teaches subjects like intellectual property law, research methodology, and drug regulatory affairs to the undergraduate and postgraduate students. Madam has authored 3 books and several research papers in many national and international journals. She was very modest not to give a biodata complete or in full profile. She was very modest at giving it very brief. She's engaged in consultation assignments for the pharmaceutical industry in the area of conventional and novel pharmaceutical and cosmetic formulations. She's also working as a freelance patent consultant for clients in India and abroad in the domain of chemicals and pharmaceuticals. We all know her as, because this name is very familiar to especially Marathi reading public. So we all know her as a column writer in reputed Marathi newspaper Lok Satta on various aspects of intellectual property, which was titled as Katha Aklecha Kandyachi. And I was one of the regular reader who is eagerly waiting for the next week's edition of this column, Madam. The column is in a very simple storytelling way, which could be easily comprehended even by a layman. The compilation of writings have been published as a book with the same name, with the same title, by Rajahamsa Prakashan. The book has received several awards, including prestigious Maharashtra State Government's award for the best book published in the year 2017 on a topic related to economics. Her 2 books that are recently published are Koronacha Krishna Chayet, obviously it is on the topic of COVID, and Ashihi Ek Zunza, on the role of Indian pharma company Cipla in the African AIDS crisis. Friends, we are very fortunate to have with us such a dynamic personality to speak on the topic IPR for academic researchers. And I request Madam to begin with her session. Thank you.
Thank you so much for the kind words of introduction. I realize even the biography is a little longer. I'll have to shorten it next time. As the topic given to me is intellectual property rights for academic researchers. Though my area of expertise in IPR is patents, I would not be focusing more on patents because the next session is going to be purely on patents. So I'll just touch base upon those areas in intellectual property which I feel should be known to academic researchers. Let me share my presentation. I hope I'm audible.
Yes,
Yes,
ma'am.
madam.
Yeah.
Yes, madam.
Yeah, so basically, what is intellectual property? So as the name suggests, it is a property that refers to creation of mind or the intellect. Property is a word very known to all of us in India. But when we speak about property, the 2 things which come to our mind is land and gold and money. Okay, but today we are going to speak about something else, which is some other form of property, which is a creation of mind. So anything which is a creation of mind, and with the help of which you can create property, you can generate money, is called intellectual property. And intellectual property rights are the legal rights governing the use of all these creations of human minds. And all the types of intellectual property, be it a copyright or a trademark or a patent, it gives the creator an exclusive right over the use of his creations. Basically, the right is to exclude others from using it. So intellectual property is always a negative right. In the sense, why I'm calling it a negative right? Because it gives the user, it gives the owner the right to exclude others. They will stop others, they can stop others from using their own rights. They would be able to use their own rights, of course, but at times it is possible that they may not be able to use their own rights, but they always can stop others from using their rights. So if I have a patent on an innovation, I can stop others from using it. If I have a copyright on a book, I can stop others from using it without my permission. I may not myself be able to use that creation. I may be able to use, but I am always able to stop others. So that is the meaning of the word. It is a negative right to stop others from using it. Just like other forms of property, even intellectual property can be sold and you can make money out of it. Just like other forms of property like land and gold, intellectual property can be inherited. These are the similarities, but there are some features of intellectual property which actually distinguish intellectual property from the other types of intellectual property. So what are these features? The first is intellectual property is always intangible. You cannot measure. You can say that I have 10 acres of land or I have 1 kg of gold, but you cannot measure intellectual property. That is the first distinguishing feature. The second distinguishing feature is intellectual property is non-rivalous. Now, what is the meaning of this word non-rivalous? We all have heard a Sanskrit Subhashitam which ends with Vidyadhanam Sarvadhana Pradhanam. The entire verse, Sanskrit verse is Na choraharyam, na cha rajaharyam, na bhratrubhajyam, na cha bharakari. Vyaye krute vardhate eva nityam, Vidyadhanam Sarvadhana Pradhanam. Now, what does this mean? Na choraharyam, which cannot be stolen by thieves. Na cha rajaharyam, it cannot be snatched away from the owner by the king. Na bhratrubhajyam, cannot be divided amongst family. Na cha bharakari, it doesn't become heavy. Vyaye krute vardhate eva nityam, the more you spend, the more it grows. Vidyadhanam sarvadhana pradhanam. So knowledge is the best form of property. That is what the Sanskrit Subhashitam says. And that exactly tells you about this feature of intellectual property, which is called non-rivalousness. So what is the meaning? Suppose I have 5 acres of land and somebody encroaches upon 1 acre of the land. I am left with 4 acres and the other person gets 1 acre. Or if I have 1 lakh rupees and somebody steals 50,000, I am left with 50,000 and the other person gains 50,000. But if I have an idea and if somebody steals it, I still have it. It doesn't get snatched away from me. I have it and the other person also has it. That is what is meant by the non-rivalous nature of intellectual property, which distinguishes it from the other forms of property. What you're seeing on this slide are the famous lines by Thomas Jefferson, who is considered as one of the founder of intellectual property in the United States of America. So he says, he who receives an idea from me receives instruction himself without lessening mine, as he who lights his taper at mine, taper म्हणजे मराठीत ज्याला आपण मशाल म्हणतो. So as he who lights his taper at mine receives light without darkening me. So if somebody is lighting his lamp with my lamp, does my light gets reduced? No, I don't get darkened if he receives the light. Similarly, if somebody receives an idea from me, he receives the instruction himself without lessening mine. And that is what is meant by this typical distinguishing feature of intellectual property, which is called non-rivalousness. And the third feature is it is non-excludable. So if you want to protect your land, you can build a fence around it. If you want to protect your money, you can keep it in your bank account. But if you want to protect your idea, can you build a fence around your idea? As soon as you start using your idea, people are going to see it and they would be able to use it. So you cannot exclude others from using your ideas on its own. You can't build fences around your ideas. And that is the another feature of intellectual property, which is when we say that it is non-excludable. Apart from that, there are some other features. I'll not go into the details of the last three, but first two are important. Generally, all forms of intellectual property have a limited period of protection. Like the life of a patent is 20 years. Life of a copyright is 60 years after the death of the author. Trademarks are perpetually protected, but you have to pay a fee for renewal each year. So it has a limited period of protection, and after the protection gets over, for example, when a patent expires after 20 years, then it comes in public domain and the innovator no more owns it and anybody can replicate it. But till the patent is alive, the owner of the patent can stop others from using it. So it has a limited period of protection. It doesn't give you a perpetual protection to your innovation. And second important feature is territoriality, which is very important to understand. You might have seen people claiming that I have a global patent on so and so. So a concept of global patent, let me tell you, does not exist. You cannot have a global patent on any idea or any innovation, nor can you have a global copyright. So what do you mean? What do we mean by this nature, territorial nature of the intellectual property? It means that if I have been granted a patent in India, if the Indian Patent Office has conferred a patent upon me, then the patent is valid within the jurisdiction of India. It is valid in the territorial limits of India. If somebody replicates, duplicates my idea, somebody infringes on my my invention in United States of America, and if I do not have a patent in America, I cannot do anything. So if I want to sell my product in 12 other countries, then I need to file patents. I need to get patents in all these countries because there does not exist a global patent. So these are the important features of intellectual property. During the question and answer session, maybe if we get time, I would like to speak upon why the intellectual property rights are territorial. Why can't we have a global patent? So I will like to address this later. These are the types of intellectual property. All the IPs are broadly categorized into two classes: copyrights and industrial property. So trademarks, patents, industrial designs, trade secrets, and geographical indicators, they all are considered as industrial property, whereas copyrights are distinguished from them. Why it's so? Because when copyright came into existence, it was considered to be the right of artists. So suppose a painter, suppose an artist has made a painting, then he would have a copyright on his painting, and he would not be, it would not be a industrial creation. It would not be manufactured on a large scale. So it was distinguished as not being an industrial property. So copyrights though nowadays when we have copyrights on softwares or when we have copyrights on sound or music CDs, it has become an industrial property, but traditionally copyrights are distinguished from the rest of the industrial property. So later we'll see that copyrights are treated separately. Like the intellectual property offices, like you will find trademark, patents, industrial designs, GI registries, which are common and they are located at one place, but the copyright board is different. The conditions of applying for other forms of IP and copyrights are different. You need not register for a copyright and you still have it. Whereas if you want to register for a trademarks, patents, industrial designs, you have to apply for it and get it examined. So that is how copyrights are different from industrial property. I'll just quickly brush through the other forms because I know that the last the next sessions are going to discuss trademarks and patents and GIs. I would not like to spend more time on that. Rather, I would like to emphasize more on copyrights for academic researchers. So I'll speak at length about that area. So trademarks, you can see, are given on words, devices, the three-dimensional device like the star of Mercedes, a simple word like Deutsche Bank, names of individuals like Ford, invented words like Kodak, numbers like 555, letters like GM, slogans like just do it, the Nike slogan, or figures like this Jaguar. They can also be obtained on colors and smells and sounds. Trademarks are basically what is the use of trademark? It indicates to the consumer who from where the product he is going to buy, from where that product is coming, who is the manufacturer of that. So we live in the era of brands today, and brand names have become so important. Our kids want to wear branded clothes. We want to have branded cars. So in this era of brands, trademark becomes an extremely important intellectual property. Then industrial designs are given on the aesthetic or ornamental aspects of an industrially used product. I'll give you an example and move ahead. For example, a car. When we are buying a car, the technical features in the car, like the ABS system or the airbags, they are the technical features of the car, and these are the inventions on which you will have. These are the functional features, and you will have a patent. You will have to file a patent on these inventions if you want to protect it. But the shape of the car is a ornamental feature. It's not a functional feature. It's a aesthetic feature or ornamental feature. And if a company wants, because we know that a layperson like this, for example, I bought a car, I bought a Baleno just because I like the shape of Baleno. I don't understand any other thing. So it is the first feature which attracts the consumer. How does the device look? So these features are protected by industrial designs. For example, shapes of cars or shapes of mobile phones, or maybe the motifs which are used in textile industry, they are all protected by industrial design, which is another form of intellectual property. And I know that you are going to have a session on geographical indications. So just to tell you briefly, a geographical indicator is a notice stating that a given product originates in a given geographical area. For example, if we say that Kolhapuri chappal, so when we use this word Kolhapuri, which is a word which mentions the geographical origin of that product, then why it is important? Because we know that Kolhapur is famous for chappals, and so if we are buying it from Kolhapur, then it has to be of a imported. It has to be of a good quality. So that's all about. Let's not spend more time on geographical indications. So these are some forms of intellectual property. Then the next important form of intellectual property is patents. As far as innovations are concerned, patents are extremely important, and patent is a right to exclude others from using your invention. Okay, so when you have invented something which is what I can say, it is novel. Let's see the features later. But patents are given on inventions which are either products or processes to make products. And if we want to protect such inventions, then patents are given. Patent is the intellectual property which you have to go for if you wish to protect it. And inventions means a new product or a process involving an inventive step and capable of industrial application. So patents are not given on discoveries, they are given on inventions. What is the difference between a discovery and an invention? Discoveries are something which always existed in nature, but you just have discovered it. For example, you go for a trek somewhere on some mountain and you discover a new species of a plant. So you can't file a patent on that plant because it is not a just a moment. You can't file a patent on that species because it was not made by you. Why basically a patent is awarded to someone? Because he has spent his time in and effort in inventing something on his own. He has invented something which does not exist before. So if you have discovered a species of the plant, you have not invented it, you have not made it. It always existed in nature and you just have accidentally found it for the first time. So you don't get patents on discoveries, you get patents on inventions. For example, gravity was discovered by Newton, it was not invented by Newton, so he cannot monopolize. Basically, when you give a patent to someone, you create a monopoly. Once a patent is awarded to someone, nobody would be able to use that. Nobody would be able to use that patent. Nobody would be able to use that invention without the consent of the owner. So in that situation, you would not. So if it is a species of a plant which is not invented by that person, it is made by nature, you cannot let him monopolize it. So patents are given on inventions and not on discoveries. I'm sure Dr. Yevle is going to cover patents at length. And the other features are the patents are given on new products or processes. It cannot be a scientific theorem. It cannot be a mathematical algorithm. It has to be a product or a process to make a product. It has to be new. So the first criteria of patentability is novelty. The second criteria is it has to have an inventive step, or it has to be non-obvious, and it should be capable of industrial application. So basically, patents are given on applied inventions and they are not given on basic science. So there has to be an application element. It has to be a technology. So patents are given on inventions which can be industrially manufactured. So novelty, non-obviousness or inventive step, and industrial application or utility are the three criteria of patentability, which I'm sure Dr. Yevle is going to discuss at length. And first, before that, if you have created something in your lab and you want to find out whether it is patentable or not, the questions you ask yourself is whether it is invention or a discovery. Is it novel? Does it have an inventive step? And is it capable of industrial application? If the answer to all these questions is yes, then probably you have invented something which is patentable. If the answer is no to any of these questions, then probably you would not be able to get a patent on these and you will have to be satisfied on a research paper. So that's in brief about patents. Let's not get into the details of this. I'll skip this. Okay, and then I come to copyrights, and I'll be speaking only about that part of copyrights which I feel is relevant for academic researchers. So when can one apply for a copyright? One can apply for a copyright on original, literary, dramatic, artistic, musical, cinematographic, sound recording works. Okay, so this original and work is applicable to each of them. It has to be an original literary work or original dramatic work or original artistic work and so on. Now, when it comes to academic researchers, and when we are talking about copyrights for academic researchers, we are basically more concerned about the literary works. But if it is an academician of dramatics, professor of dramatics or professor of music, then definitely it can also be a or the professor of fine arts, it can also be a copyright related to musical or dramatic or artistic or cinematographic works. So when can one apply for a copyright? When you have created a literary work. A literary work can be a research paper, it can be a novel, it can be a story, it can be a poem, or anything which is a literary work. It can be a dramatic work, it can be an artistic work, it can be a sculpture, it can be a painting, or it can be any new kind of art. For example, it can be body painting, it can be tattoo, and so on. It can be a musical work. For example, you know that when we listen to songs, basically film songs, the songs have lyrics and the songs also have music. Okay, so the lyrics of the song are literary work, and the music composition is a musical work. So if we are talking about music, and then if it is an instrumental music, then there are no lyrics in it. But if it is a music which has lyrics as well, then most of the times the lyricist is different and the music composer is different. So the lyricist will have copyright on the lines, on the lyrics of the song, whereas a music composer will have rights on the music composition of the song. All right. So it can be a musical work, it can be a cinematographic work. So it can be a, if we are talking about a cinema, then the cinematographic part of that, the cinematographer will own the copyright on that. The movie always has a story and it has dialogues, it has screenplay. So all these dialogue writer and the screenplay writer and the original story writer will have copyrights on that part of it. The movie also has songs and the songs have lyrics and they have composition. So the lyricist will have copyright on the songs, on the lyrics of the songs, and the composer will have copyright on the composition of the song, and so on. Copyrights are also given on sound recording works. The first and the last word is very important. What is the criteria of getting a copyright? Number one, it has to be an original work. It doesn't tell you how creative that work has to be. So all of us know that when during our college days, say if there are 50 people in the classroom, 40 out of 50 in that age, at that age, everybody feels like writing poems. Okay, most of the times these are love poems, but few of them are very good and few of those write very bad. But copyright does not say that copyright will be given on good poems, very creative poems, and copyright would not be obtained on bad poems. No, nothing like that. So there is no criteria as far as the creativity is concerned in that work. It just has to be original. It should not be a work which is stolen from someone else. So the only thing is it has to be original. Then the second criteria is it has to be work. Very important to understand this. What do we mean by it has to be a work? So for example, okay, before we discuss about, let me let me tell you what do I mean by work. So all of us have seen several Bollywood movies, and we know that most of the times, most of the Bollywood movies were based on a single idea of love triangle. And that is what I'm trying to show in these posters. These are the very old movies, and this is a relatively newer movie, but the common factor in all these movies, and there are many more like this, that the love triangle. It can be other way around as well. So one hero and two heroines, or two heroes and one heroine, or the heroine is from rural area and the the hero is an affluent urban person, and so on. Or there can be differences in caste or economic status, but the basic idea is love triangle. So had someone copyrighted the first idea of writing a movie on love triangle, if somebody had obtained a copyright on that idea, then the rest of the movies wouldn't have been made. But then why the other movies could be made? Because one cannot copyright an idea. Okay, one cannot copyright an idea. You have to convert it into a work. What do I mean by this? So writing a movie on a love triangle is an idea. Okay, but when you write a book on that, write a novel and fix the idea in the form of some expression, write a book or write a novel or write a script of the movie, that is called as work. Okay, till that time, suppose I have an idea of writing a book on something and I discuss it with my friend before writing it, and I don't work upon it for many years. Then the friend writes a book on that story and he publishes the book, and then you realize that hi tar माझी idea hoti. Then can you sue that friend for infringing on your copyright? No. That's because ideas cannot be copyrighted. They must be fixed in some form of work. You have to express that idea in form of some work, and copyright is obtained on the expression of that idea and not on the idea itself. So what are the rights of copyright holder? These are important for us because we either end up using someone else's work without giving the credit, or we also face our works being copied. So what are the rights of copyright holder? You can stop others from making the copies of your work. You can stop others from making derivative works. What are derivative works? Translations and adaptations. So making a movie based on a novel is adaptation. Changing the language, that is translation. So adaptation and translations are two types of derivative works. You can stop others from displaying your work. So if you have created a painting, nobody can exhibit your work in an exhibition without your permission. The right to stop others from distributing your work, and right to stop others from performance. So we all have sung songs in during our college days, in the college orchestras or socials. So if we are doing that without taking the permission of the owner of the copyright, that is, if we are not asking the music composer and we are singing in an orchestra, then that is infringement of copyright. So if you want to perform someone else's copyrighted work, you have to take the permission, and obviously you have to pay the royalty. So these are the rights of copyright holder. And as I said, this is a great debate of copyright law, idea and expression dichotomy. So if somebody has stolen the idea, but the expression is different, then it is not considered infringement of copyright. One is said to have infringed someone else's copyright if he has stolen the expression. Let me give you an example. Those who do not understand Marathi, please kindly excuse me. So these are the very famous lines by poet Balkavi. श्रावणमासी हर्षमानसी हिरवळ दाटे चोहीकडे क्षणात येती सरसर शिरवे क्षणात फिरुनी ऊन पडे. ही मराठी सगळ्या मराठी लोकांना माहित असलेली अतिशय फेमस कविता आहे. Now, if I try to steal this, write a poem on my own by stealing the words from this, what I write is Madhunacha yeti sarasara dhara. So shirve I have replaced by dhara. Madhuna kovale un pade. Shravana masi anandamani. Harshacha ऐवजी I am using ananda. Manasicha ऐवजी I am using mani. Shravana masi anandamani. Hirave hote chohikade. Okay, so what do you think? If I am writing these lines, am I infringing? This poem? Yes, because I'm not only have copied the idea of writing a poem on Shravan Mas, I'm also have copied the expression. Okay, I have copied the words by slightly tweaking them. So if what you have copied, what one has copied is the copy of the expression, then it is considered as infringement of copyright. But if it is a copy of idea, so if someone writes a poem on Shravan, but the words are entirely different, then it would not be considered as infringement of copyright. Now, why I said that it is so important in academics to understand copyright, because there is a doctrine in copyright which is called fair use of copyright, and it is very important for the academic researchers to understand what is it. So I told you that what are the rights of copyright owner? The rights are to stop others from making your work in either of the way. So either you are quoting someone else's work on your name, you have translated or you have made a derivative work without his permission, you are displaying, you're distributing, or you're performing without taking the consent of the copyright owner. But it is not, if somebody does it without the permission of the copyright owner, it is not always considered as infringement of copyright. And that's because that's because there are some limitations of copyright, where even if you have infringed the owner copyrighted content, it is not considered infringement, and that is called as fair use doctrine. So fair use is a statute under copyright law that allows for the use of limited portions of the work that has copyright without having to have the permission of the original author. If you are copying someone else's work without his permission, but under what conditions? You are not copying the entire work, you are using a very limited portion of someone else's work for educational purpose, for private personal use, for news reporting, or for judicial purpose. So if you're doing that and you have not taken the permission, still it would not be considered infringement of copyright. It is considered fair use. But what are the conditions to fall within the fair use doctrine? Number one, you have used a very limited portion, and you have used it either for educational purpose, for private personal use, for news reporting, or for judicial purposes. So even if you have not taken the permission, it would not be considered copyright infringement. Now, why I'm saying that it is very important for academic researchers, because we fall here. Whatever we are doing in our profession, we are doing it for educational purpose. So it would be considered fair use if you are using a limited portion. Now, where all we see that we are using someone else's work without the permission? Number one, we are getting the books photocopied from our library. Do we ask the author of the book to for the permission before photocopying? No. So ideally, it would be it would be a copyright infringement. But if we are using it for an educational purpose, that too, we are not photocopying the entire book, but we have just photocopied one chapter, which is a one limited portion, then it would be considered okay. If you are writing, you are quoting a line from someone else's research paper in your research paper, it is for educational purpose. Okay, so it would be still considered okay, because it falls under fair use of copyrights. So whether it would be considered fair use or not would be decided by the courts by applying this 4-point test. So when will you say that it is fair use of copyright, and when will you say that it is copyright infringement? These are the 4 questions you should ask. What is the character of the use? What is the nature of the work to be used? How much of the work has been used? And what effect would this use have on the market value of that product? For example, what is the character of the use? If you have used this for, if you have used this for criticism, so if you are criticizing someone else's work, you have to use the lines from his work, or you are commenting, you are writing a commentary or criticism, or you are news reporting, or you are writing a parody, repurposing of a work, providing a new context, or otherwise adding a value. So if you are doing it for this purpose, then it would be generally considered as fair use. If you are doing it for a commercial purpose, then it would definitely be considered as infringement. If you are doing it hey jai, these things are definitely considered fair use, and this is considered infringement. This is a gray area. So if you are using it for non-profit work, for educational purpose, and for personal use, then most of the times it would be considered as fair use. So character of the use, yatyapeki, if it is falling under these categories, then it would definitely be considered as fair use. What is the nature of the work to be used? The work which you are trying to copy, what kind of work it is? Is it a factual work and a published work like most of our educational books are? These are the facts, okay? But if it is a unpublished, imaginative, highly creative work like a novel, so if you are copying this, then it can fall under fair use. But if it is imaginative and creative and unpublished work, then it would definitely be copyright infringement. How much of the work is being used? Now, how much has not been told, that how much is okay, but around 10% is considered okay. So if you are using a small quantity and an appropriate quantity for a transformative purpose, then it would be considered fair use. But if it is a very large quantity, or if you have copied the entire book, then it would be considered copyright infringement. What kind of use, if you are infringing upon it, what effect it would have on the market of the original work? So if it is going to reduce, for example, you find books being sold on the footpaths, okay? So if the original book is for 1,000 rupees, the book being sold on the footpath is available for 100 rupees, and it is a copyright infringement. That book has been printed without taking the permission of the owner. So if a book is being available in the market for 100 rupees, then who is going to buy the book for 1,000 rupees? No, nobody will buy. So it is going to affect the market of the original work. If it is going to affect the market of the original work, then it is infringement. If it is not going to affect, so for example, I have quoted a paragraph from one published book. Is it going to affect the market of the original work? No. So it is likely to be considered as fair use. I'll skip this case and directly come to a case which has an Indian context. And this is a case which would be very important to all of us academicians. This case is considered as Publishers versus Delhi University and Parmeswari Photocopy Shop. So what happened? This is a political sciences department in Delhi University. And what happened was the political sciences department syllabus contained all reference books, and the textbooks were not available. The books were very expensive. They costed some 10,000 or 15,000 rupees each. So only single copies were available, the reference copies in the library, and the textbooks were not available. So the professors from the political sciences department, what they did was they created a course pack. So what they did was book number 1 say one chapter liya, book number 2 say dusra chapter liya, and they prepared a course pack and they asked the students to use it. This was done by the professors of the university, which means it was done by the university itself. Now these course packs were being photocopied in a shop called Parmeshwari Photocopy Shop, which was owned by the university. You know that the universities have Xerox shops. So this course pack was being photocopied in the university, and then it was being sold to the students. This was not a commercial use. The charge which was the amount for which the students were charged was only for the cost of photocopying and spiral binding. Now, these books which were converted into course packs by the university, they belong to Oxford University Press or Cambridge University Press or Taylor Francis. These were the famous publishing houses. So these publishing houses filed a suit against Delhi University and Parmeshwari Photocopy Shop, saying making such kind of a course pack is infringing on our copyrights, and they asked for a compensation of 50 lakh rupees from these two, that is Delhi University and Photocopy Shop. Now this case went to the High Courts, and the High Court said that this should not be, let me skip this, but the High Court said that this should not be considered as a copyright infringement, because then they again applied this 4-point test. So what is the character of the use? It is for educational purpose. Okay. What is the nature of the work to be used? It is informative work. It is not a creative work. It is a published work. How much of the work has been used? 1 or 2 chapters from each book, not the entire book. What effect this would have on the market of the original book? You can say that it will affect the market. That was the argument by the publishing houses. But the university said that the publisher's book are available at 10 or 12,000. Even if we don't publish this course pack, the students would not be able to buy. And under Indian Constitution, right to education is a fundamental right. So because of your copyright, if the students are not being able to access the right to education, then the constitutional fundamental right takes a priority over the copyright. And if it is stopping the high prices of the books, why the books are expensive? Because they are copyrighted. So if the high prices are stopping the students from accessing their right to education, then this should be considered fair use of copyright, and it is okay if they use it. The court said that copyright, especially in literary works, is thus not an inevitable divine or natural right conferred upon the owner, or conferred on authors the absolute ownership of their creations. It is designed rather to stimulate activity and progress in the arts for the intellectual enrichment of the public. So if it is not possible to use it for the intellectual enrichment, then the copyright is of no use. Copyright is intended to increase and not to impede the harvest of knowledge. It is intended to motivate the creative activity of authors and inventors in order to benefit the public. So moral of the story is the High Court said that if the books were copied for, number 1, educational purpose, number 2, because they were highly priced and they were stopping the students from accessing the right to education, then this has to be considered fair use of copyright. So this is a very, this is considered as milestone in the copyright jurisdiction, and it is very important for us academicians, because this can always happen with us. This can always happen with the books we keep in the library. So if you are keeping photocopies of the books in the library, entire book, photocopy of the entire book, then though it is for educational purpose, it is definitely copyright infringement. Another important thing which happens which is related to copyright infringement is plagiarism in academics. So plagiarism, we know, is the act of stealing someone else's work and attempting to pass it off as your own. So you steal someone else's work and you don't give the credit. That is called as plagiarism. So you pass it off as your own work, which actually is not. This can apply to anything from term papers to photographs to songs, anything that is protected by copyright. If you try to pass it off as your own without giving the credit to the original creator, then it is considered as plagiarism. There are different types of plagiarism, like copying. So it is the most well-known, and when a person is lazy then he will do this type of plagiarism where he will word to word copy someone else's work and pass it off on his own. So this is someone else's work which has been word to word copied and passed off without giving the credit. Okay, so this is one type of plagiarism. Then another type is patchwork plagiarism, where what you do is the plagiarizer borrows the phrases and clauses from the original source, and in between he puts his own words. So he weaves them into his own writing. So partly it's his own writing, and partly he has borrowed from someone else's. And most importantly, he is not quoting the source. He is not giving credits to the original author. So you have to put the words which you have borrowed from others in quotation marks and give the credit that so and so had said it. Then it is not plagiarism. But if you are directly writing it and passing it off as your own, then even if you have done this type of patchwork, it is plagiarism. This is just to give you an example. So the right sentences in purple are borrowed, and in black are the plagiarizer's own sentences. This is patchwork plagiarism. And third type is paraphrasing, where this occurs when the plagiarizer paraphrases or summarizes author's work without citing the source. He had changed the language, but the thoughts are someone else's, even changing the words a little or using synonyms, but retaining the author's essential thoughts. Sentence structure is same. He had just changed certain words and or style without citing the source is still considered plagiarism. So this is an example. Sometimes you unintentionally, the work is someone else's and you quote some other author's name because of out of ignorance. So this was unintentionally done by you. It was not done on purpose, but this is still considered plagiarism. So you have to take efforts to find out who the original author is and give credit to him only. So in order to avoid plagiarism, the best policy is to simply be honest. If you have lifted it from someone else's work, please put it in quotation marks and source, please quote the source. Give credit where it is used. If you want to use a major portion from someone else's work, try to take his permission. If he at least try to send an email to that person. So even if he does not reply back giving you the permission, the email will come in your defense. So, and we also know that there are some free plagiarism checking tools available. Your university might also have shared a plagiarism tool. These are some freely available plagiarism check tools which can be used, like EduBuddy or Plagiarisma or DupliChecker. These can be used to check if you are plagiarizing. So I feel that was all about, I kept the copyrights as the focus of today's talk because others were going to talk about patenting and GI and trademarks. So with this, I come to the end of my session, and I'll be very happy to take your questions. Thank you.
Yeah, thank you very much, madam. Indeed, it was a very interactive kind of session in the sense there are many questions, and it was full of knowledge on the world of intellectual property rights. Particularly, you dealt in details on copyrights, and that too with which is more relevant to academic research. Now, may I call upon Organizing Secretary Dr. Subhas Donde sir and Head of Botany Department Sathe Madam to take over this question answer session.
Yes, sure.
And we'll spare 10 to 15 minutes for question answer, though there are many, but I think the moderator can club the questions. Sir, over to you now. Donde sir?
Unmute yourself, sir. Donde sir. Unmute yourself.
Yeah. Good morning, madam.
Good morning.
Yeah. There's one question from my colleague who is head of the statistics department. She has worked on some aids. She has developed, created one model which is useful for doctors to take decision. She has created one model on AIDS which is useful for doctors to take some decision. So can she file the, so in this situation, can I apply for patent? If yes, what are the steps I have to follow?
What kind of model? Let me tell you first that we are speaking about law here. And most of us who belong to science stream, we are used to having unequivocal answers to our questions. Generally, in the area of law, you would not get an answer like yes or no. Okay. So when you ask that something is patentable, the answer would never be yes or no. The answer would always be it depends. Okay. So it depends on what. Then I told you in the next session, probably you will have a more clear idea about it. But I told you, you should ask these questions, that whether it is a product or a process.
Yeah.
Is it novel? So you have to check the novelty first. Are you sure that nobody else in this world has created? Basically, is it a product or a process? Then if yes, then is it novel? Does it have an inventive step? Does it have an industrial application? And if the answers to all of these is yes, then probably you would be able to have a patent.
Okay, I'll ask some questions from your core area, that is from pharmaceutical science or drug, which you are dealt. Actually, you dealt with the Copyright Act.
Yeah.
Please let our audience know the unique provision of our IPR in brief, which is beneficial for availability of generic drugs to third world countries.
Great. You are taking me to my area and I tried to deviate a bit. No, generic drugs have got nothing to. So basically, when the patent on a drug expires, okay, I told you the life of a patent is 20 years. Out of that, the time required for regulatory approvals, you can't sell a drug without the permission of the regulatory authority. So if you are going to sell a drug in the US, then you have to take the permission of the US FDA. And for that, you have to do the clinical trials. Today, we have got acquainted with this word of, even a layman knows what a clinical trial is, thanks to COVID. So this takes a period of about 8 to 10 years, 7 to 8 years. So from the life of 20 years, 7 to 8 years are gone. Okay, what is left is 12 years. So during these 12 years, the drug would not be available as a generic drug. The company who has innovated that drug, who has invented that drug, only that company would be able to sell because it is patented. But the day the patent expires, the next day, other companies can replicate that drug and they can use all the information disclosed in the patent. They don't have to pay for it. They can use that information and start making the drugs. Now, what is the advantage here? They have not spent any time on research. They just have to show that their drug is at par with the innovator's drug. And the regulatory approval takes a shorter time. So after that, the drugs which become available in the market after the expiry of the innovator drug are called generics. So you don't need a provision in the Patent Act to sell a generics because the patent is off already.
Okay. I have a question about the drug which are repurposed. Now the drug is developed for some particular disease and later on we discover the new use of the drug.
Right.
So what are the patent provision for the drug which is now, which has got new function for new disease?
Yeah, I'm very happy to tell you that in Indian Patent Act, you don't get a patent on the repurposed drugs. So second medical use is not patented in India, but in rest of the world, you do get patents. But then in India, once the, so take an example of aspirin. Okay, the first use was antipyretic and now it is used as an antiplatelet drug. So after the expiry of the patent, somebody if discovers the second medical use and tries to patent it in India, he will not get a patent. That's because Indian Patent Act is fully in favor of access to medicine. What we think is we have to give better access to our people because they are poor. So Indian Patent Act is in favor of common public when it comes to drugs. It's not the same in the developed world like US and Europe.
Thank you, madam.
Yeah.
You told that you are going to say something about territorial rights of the patents at the end of the your talk. So
Yeah.
kindly highlight on
The
territorial
same
rights
thing
of
which
the
I
patent.
was trying to say, that see what happens is when you give away patents, you create monopolies. When you create monopolies, what happens is the things would become, or the patented invention becomes expensive. And when it becomes expensive, because there is no competition in the market, there is a monopoly, nobody else can make it. So take an example of a new television which has come into the market, and it has a fantastic technology. For example, you can actually roll the screen of the television and put it in the cupboard. So it's an excellent technology.
Yeah.
Now the technology is patented, so it is being sold for 2.5 lakhs. Okay, because nobody else can make it. So how many people in India would be able to afford this television? Very few. But then it's okay if everybody cannot afford, because it is a luxury good. You watch a movie on a 20,000 television, it's okay. But apply it to something called like drugs. So a new drug on cancer has come in the market, which can cure one type of cancer. And there was no cure available before that. The cost of the drug is 5 lakh rupees per treatment cycle. Now, how many can afford in India? Very few. But can you apply the same logic of television here, that those who can afford will buy, those who don't afford, it's okay? No, you can't say it here, because those who can't afford will die. Okay, so when it comes to life-saving medications, then you can't afford to have patents on anything and everything. Okay, and that is the reason, because every country in the world does not have the same economic status. For poorer countries, the patent policy should be in favor of poor people, layperson. And for richer countries like US and Europe, the patent policy should be in favor of innovator. Okay, and that is the reason a thing which is patentable in US may not be patentable in India, because India and US have different patent acts. And why the patent laws are different? Because the economic status is different. So in IP, we say you can't have one size fits all approach. Because the economic health is different, you have to stitch the shirt according to your size, the shirt of IP policies.
Okay. Madam, I got one question related to TB Alliance. It's a global alliance for development of new drugs for TB. So in that there are 35 partners.
Yeah.
So they have come up with the 3 drugs recently, because there were no new drugs for last 40 years, and new drugs have come to treat the totally drug resistant TB. So in that case, who holds the patent for that new drugs?
No, there is something called as a medicine patent pool. I have to check whether they have. So medicine patent pool is in which you can put the patents generously, and you can free them of IP rights. So anybody would be able to use it at a mere licensing fee.
Okay, thank you, madam.
Thank you.
Now over to Sathe madam.
Thank you, sir. Thank you, Mrudula madam. You had explained very nicely this topic and in simple manner. Now there is one question from Veenie. She is asking that how we can define the limited portion. And one more question is that from her only. That is, we are using these relevant pictures on our slides from the internet for our academic purpose. Is it infringement of copyright? Hello, madam.
Yeah. So first thing is, if you go to Google Images, to be on safer side, if you go to Google Images, there are different screening available for the images. Size किती मोठा हवा वगैरे, त्यात नवीन एक फीचर ऍड झालंय की can we have a free license free photograph. So if you you click that link, you will be able to obtain license free photographs which are free for use. Number one, it is the safest option. Number two, even if you are using a licensed photograph, you are using it for an academic purpose, just be kind enough to give credit to the source. Just write it that the image is obtained from so and so website. would be enough and would not be considered as infringement.
Okay. Okay. There is one more question, last question, madam. Gaurav Parab is asking, how could we use copyright in judicial purpose? Because in judicial purpose, ideas are same. So it will be unfair.
No. I meant that for when you are using it for judicial purpose. So if you are submitting a proof or when the decision is being given by the judge, and if he is quoting a paragraph song from some book, then it would be considered fair use. That is the meaning. Or if you are using it for reporting of some event on news channel, you are using a clip from a movie for reporting on a news channel. So that would be considered fair use. Similarly, if you are using it as a proof, you are submitting as a proof in the court case, then it would be considered as fair use.
Okay. So how we can define that limited portion?
No, it hasn't been defined in law. So when something has not been defined in the law, then it can be obtained from the precedents. So I did not discuss the Google copyright case, which happened in the United States of America. But during that case, the United States court said that 10% would be considered as limited portion. That is in US. So if you want to follow the same jurisdiction in India, it would be considered 10%. But because the economic status in the US and India is different, we can safely say that 20% should be limited portion in India.
Okay, thank you. Thank you very much, madam.
Thank you.
Now this question and answer session is over. Over to Joshi sir.
Okay, thank you, Sathe madam and Donde sir. Thank you very much, Mridula madam. May I now call upon Dr. Jyoti Munde to propose vote of thanks? Munde madam?
Yes, sir. Am I audible, sir?
Yes, yes.
Yeah. On behalf of Research Promotion Committee, IQAC of Kirti M. Dungurji College, Dadar, I am here to propose vote of thanks to the resource person of today's first session, Dr. Mridula Bere. At the outset, I would like to say thank you to you, ma'am, for accepting our invitation in spite of your busy schedule, because when I called you, I realized it. And at the same time, I also express my gratitude towards you for delivering such a beautiful lecture, because it was, as you say, that it has to be very comprehensible to the lay persons also. So although I'm do not have any background for law or pharmacy, I could understand your lecture very well. And also I thank you for taking all the question answers and patiently replying to all of them. Thank you so much once again.
Thank you.
Over to you, Joshi sir.
Yeah, thank you, madam, Mridula madam.
Thank
now
you.
we move towards next session.
With
kind
permission, I would like to leave. Thank you.
Yes, please. Thank you very much, madam. Yeah. Yeah. May I now call upon Dr. Smita Patgaonkar, Head of Statistics Department, to introduce next speaker of this webinar, Dr. Niranjan Yevule. Over to you, Smita, madam.
Thank you, sir. Good morning to one and all. A very warm welcome to all for the second session of national webinar, which is on IPR, what researchers need to know. It's a great honor to me to introduce today's speaker, Dr. Niranjan Yevule, who is going to speak on the topic research and patenting. As all of us know, researchers seek patent protection of his and her research work. Sir has contributed almost his entire career in this field. Our today's resource person is not only a scientist, but also he is an intellectual property professional and experienced researcher. Sir, I extend my warm welcome to you. Now, let me highlight Sir's profile in brief. He has completed MSc and PhD in polymer chemistry from North Maharashtra University, Jalgaon from 2008 to 11. He also has to his credit postgraduate diploma in patents law from Nalsar University in 2016. And his research experience include his association with Syngene International Limited in 2007, with University of Hyderabad as a Dr. D.S. Kotari postdoctoral fellow from 2012 to 14, and 10 international research publications on his credits. Our guest speaker today have vast industrial experience like working with Dolsara ITES in Hyderabad and PI Industries as IP analyst. Currently, our speaker is a scientist associated with Intellectual Property Group in CSIR NCL Pune for managing responsibilities related to IPR. Sir, we are really fortunate to have you here on this day for the session. And with this, I request you to start the session. Thank you.
Thank you very much for a kind introduction. I hope I'm audible.
Yes, sir.
Yeah.
Yes, sir.
So first of all, thank you for organizing committee and to the management to letting me part of this webinar. So I will directly jump into the slides since so much of background has already been shared by Dr. Vile in our earlier lecture. Yeah, I hope slides are.
Yes, sir. Yes, sir. Visible.
Okay, so the topic we will be discussing about research and patenting. Since basic IPR is already been covered in the first lecture, we'll directly jump into the patenting part and how this research and patenting go all together in development of any kind of development in particular technological domain. So what are the goals of this talk? We will understand the role of IP protection in that research or the technology development. And in latter part, we'll also understand the patent life cycle, how the patent starts with, means from application part till the end, kind of a granted ones. So we'll go into details. So the outline, what we'll be covering, why IP matters, even though we understand what is IP. But again, we know that importance, but we should also know why it is important. Importance of patenting also will be highlighting. So who needs patent information? Benefit of patent information. This is kind of a similar one to the who needs patent information. Accordingly, the benefit of patent information will also be changing. We will understand the patent basics using one of the case study. Key terms in a patent. We'll see that what are the contents are in patent application or a granted patent. Type of patent searches, steps prior to patenting. So we should also have a homework ready before going for any patent filing. So what are the key steps? We'll also understand those steps. As I said, in goal that the patent life cycle, we'll see that patent life cycle in more detail. And one case study where we will see that how this research plays an important role. Patenting plays a very important role in research planning. So first and foremost, why IP matters. You could see in the graph that down the line over the period, the IP is a very essential part of your strategy. For example, you can see in 1975, you also understood in previous lecture about the intangible and tangible assets. The intangible, which you cannot measure, the tangible ones like the land or gold, any property, the tangibles, you can measure it. So intangible considers the IP as a main part in intangible asset. In 1975, you can see that the intangible asset for this S&P 500 companies were very less compared to the today's scenario. So this chart belongs to the S&P 500 companies. S&P 500 companies is similar to the Sensex what we have in India. The S&P 500 is kind of a stock exchange in US. So this is picture will give you the highlight how this IP is gaining much of an importance in any industry. So in 1975, the percentage was very lesser for intangible assets one. And over the period of time, you can see that in 2018, the intangible asset has grown up a very high stakes, means it has a very high stake compared to the tangible ones. So you can see in 2018, the companies were only having a 16% value of their tangible assets, which covers the real estate and equipment part. Whereas in intangible, the IP rights and reputation, the brand building for any industry, it is almost like 84% in today's scenario. And it is going to change more drastically in coming future. That's the reason now even government of India is also focusing more and more importance towards this IP, and we all should be more aware of, because future is a new kind of invention and which is changing whole dynamics of industry. So I talked this in 1995. You can see this this change. It came into the picture in the 1995. From there, the graph is changing very drastically compared to the earlier years. So even if you think of 2030, you will see that this intangible asset will have almost like 95% of a contribution in total assets of industry. So in that sense, you also have to be very future ready. If you want to be in the competitive world, you want to be in there. So now we'll see that importance of patenting with this one of graph for this particular molecule, Humira. This was developed by BSF. This is a molecule which is a monoclonal antibody. In earlier years, this molecule was used for rheumatoid arthritis. And over the period of time, it has a multiple indications. Means the same molecule can be used in different applications. Earlier, it used to be in arthritis. Nowadays, it was used in even skin diseases as well. So, if I have to talk about history, you will understand how this patenting is playing a crucial role for this particular molecule. As I said, this molecule is developed in late 90s. To be precise, it's in 1998. This molecule was developed by BSF in collaboration with the Cambridge Antibody Technology. Now the patenting was started over in 1998. And we all know that the term of patent is 20 years from the date of priority. So you will see that even after the tenure of that 20 years, this molecule is still going good in the market. Why is it so? Because people are exploring its other applications and they are filing those applications for that application new patent. So ultimately, industries are also getting economical gain so that much and much advancement is also taking place for this particular molecule. As I said, this molecule was developed by BSF. This was purchased by Abbott Laboratories in 2000, and the cost for this total portfolio they took over in only 6.9 billion. This molecule was denoted as a D2E7 during that period of time, and you can see that this molecule in 2017 itself have a approximate sale value of 18 billion. You can see that almost 3 times the total portfolio they buy Abbott. In the single year, they got almost 3 times of what they have paid for. So you can understand because the Abbott was kind of a future ready. They were having a planning ready how they wanted to develop. And so accordingly, they purchased take over this BSF Pharma during that period. And now see, they are gaining much of a fruit because they were having this understanding how that can be beneficial in future. So as I said, this multiple applications are also being considered for this particular molecule. you can see that it has 75 other patent applications, and that term of patent for the new applications, it is stretching up to 2032. So you can see that it should end its monopoly by 2018, but still, even after that, it is having a patent life cycle for this molecule for different indication, not for the rheumatoid arthritis, but for a different kind of a skin applications and all. It has a stretching of their patent term by 2032. And again, this particular molecule is considered as an orphan drug. Because of that, it, it got a market exclusivity in 2015. So we'll understand, we saw this in terms of industrial approach. Now we'll see one of the non-profit institute. For example, IMAC. It is situated in Belgium, and this is a public research institute. This provides an ecosystem in the domain of nanoelectronics. And how they work, they have a multi-party research collaboration among them. So it's a bridge between industry and academics. So they are even this they have merged recently with the Flemish Digital Research Center IMIDS in 2016, but still they are going strong. I will request all of the participants to go do a Google search and go into their landing page. You will see that how this IMAC is portfolio building they are doing, and you can also see that virtually their most how they are playing a role in this nanoelectronic technology development. So as I said, the always a patenting, it's kind of IP protection plays a very important role in any technological development. So you can see in 1984, they were running on a public support. You can see that its revenue in 1984 was 6.5 million. Now in present scenario, they were having almost like a 300 million euros of revenues. And as I said, that public contribution for this IMAC was 90% during initial years. Now you can see that even in 2011 itself, they were having only 15% of public contribution. So why is it so? Because they had this industry affiliation program, so that industry were sponsoring much of their research. So, so that means they are kind of a self-sustained down the line. As I said, again here, patenting and all kinds of IP protection playing a very crucial role for developing this IMAC. And you can see that in 2011, almost 2,000 people were working with this industry, with the 600 industrial residents. As I said, it's a multi-collaborative project. So you can see that industrial residents were there. So ultimately, all the cash flows and will be taking part on in this development. There are also PhD students and guest researchers also part of it. Today, at the moment, they were having almost like 4,000 people from 100 different jurisdictions. So you can see that not only patenting, it's a collaboration which also develops the technology in a very faster way. And they have a collaboration with almost 200 universities. They give it's a kind of a dual PhDs, means sponsorship from industry and learning from IMSC. So they do have their own state-of-art infrastructure. They provide access to fund and academic like environment over there. And as I said, that patenting again, research output of PhD thesis is selectively patented. So they are thinking of patenting right away from start itself. So you all should also think of in that angle only. You should develop your research theme in such a way that it can be patented, and which will have a fruitful gain not only for you as well as organization where you're working. So patenting, along with this comes a background knowledge as well. So output of its basic research initiatives as a background knowledge. So what happens once you have a patent protection, you try to consolidate all that knowledge in the particular area. For example, in for our own lab, earlier whatever the patent we had filed in 2000 itself, we have those live patents as well. Considering those are used as a background IP for any new future project we are proposing to any industry. So you can understand that your earlier filings are also helpful to build portfolio and to approach new industries. So you can understand the patenting importance for this from this also. Now, who needs patent information? R&D professional, as I understand most of you are from masters, those will be going in PhDs or in research. So consider you yourself as an R&D professional. So you need to have this patent information with you if you want to be successful in future. Because earlier people used to ask what other knowledge you have during the interview. People used to say, I know this Microsoft Word, Excel. If you answer that, I know about this IP aspect as well, immediately your scenario will change. That interviewer will think that you know more than other resume which he is having in his hand, and he will think talk with you in a very technological way than rest of the people who doesn't have this kind of knowledge with them. Entrepreneur, for example, if in future you will be having any startup or you will be building any business, you also need to have this patent information for strategizing your portfolio. Business professionals also need patent information to plan or to strategize how their industry should move ahead in this competitive world. Public policy maker, for example, in environment and health sector, this policy maker need to have a close watch. For example, in COVID scenario, India issued a proposal to for this waiving of this IP rights during this COVID pandemic for the medical application invention. So they also have to have this patent information in hand to make a guideline so that it will be more beneficial to all the public. So in earlier side, we saw that who needs patent information. Now we'll see the benefits of patent information. First and foremost, the patent is for protecting yours or company's investment. So for example, you are an R&D professional, you are working for some industry. So you need to protect whatever work you are doing in that particular domain. Otherwise, if you are a solo inventor, that investment also has to be there in a proper way so that you can protect your invention in a proper way. So you need to have a patent information to protect your invention. For perfection, means it will avoid duplicating research. If you have this patent information before starting in your work, otherwise you will be investing a lot of your resources and time and cost, which is already been developed by someone else. It's a waste of resources as well as time. So before starting any inventive work, you should have a background ready. We will see that from where and how you can get it. That's kind of a state of art or landscape research study you should do before starting your research, so that it's kind of a homework for you. So before investing your much of a time and resources. And if you know that something is already known, you can think of other ways how you can solve that that problem by a different approach, which is already been patented by someone else. It gets published, so the patent gets published. What benefits you had? You can avoid infringing someone else's patent, so that he has something means already someone has filed a patent application. You should not come into their fence, so that you should avoid infringing someone else's patent. And being a start of your career, there are multiple approaches you can avoid infringement. That comes in latter part of career. It's also a strategic planning part. As I said, that business planning decision on licensing and technology partnership. So if you're infringing someone, it doesn't mean that you should stop. You can approach that in first filer to have a licensing agreement between both of you. It will be beneficial for him because he will be getting some kind of a transaction from your end. So he will be also happy that someone is also using his invention. But it is not the case always. It depends on the other, who is the person who has filed first patent. And as well, the planning is important. Why? Because you can monitor your research activities of competitors who are coming into the that domain which you are working. For example, in our earlier industry where I worked, we used to have a close watch. Whatever the patents were coming into the public domain. For example, PCT application, those comes every Thursday in public domain. We used to have a patent watch activity for that. So every Thursday we used to watch who else has come into the this particular area which we are working, whether that application publish is hampering our research activity. We used to strategize accordingly whether we should proceed or not. We used to take a decision on that matter. So that these are the kind of benefits of patent information which you can gain and which will help you to define your strategy. Now we'll understand the basics of patent using one of the case study. See, many of you know Braille codes, but how it has been developed and who has developed Louis Braille, many people know, but we'll consider this as a case study to understand the patent basics. So this boy was born in 1809 in Paris, France. So at the age of 3, this Louis injured his eyes. Hence, he was not born blind. He because of injury, he got blind while working with, not working, while playing with his father in his garage. He injured both of his eyes. In 1820, you can see that in 11 years, there was only one way of reading. It's kind of a raised print each letter by on a page, so that people used to read during that period of time. Then Louis Braille thought of why there should be not a tool which is very beneficial to all blind people. So in 1921, think of his age. Okay, he is only a 12 years kid. He saw that one of the army soldier, Captain Charles Barbier, he used to send messages in a dark night writing, used raised dots. Those dots were pushed into heavy sheet of paper with a long pointed tool, which is called as a stylus. So he saw that he's sending some of information to the soldiers using this night writing raised dots. So this Louis Braille thought whether we can use such method for blind people to read and write. So this boy worked really hard to define this Braille code. You can see that all dots are of a different, means, for example, A is having a single dot, and it's a kind of a 3-column what we call presentation. For each alphabet, it is having a different raised dots. And even for few of the words like for, if, which we used, he developed for such words also. Even the symbols, plus, minus, it is having a different presentation as well. And even numbers also. For example, 1, he given a presentation of similar to the A, but if someone has to read the numbers, he given some indication that from here onwards, number style is going to start. So he worked really hard for to develop any system which can be used by the blind people. As I said, this boy forgot to sleep or eat. So as a researcher, you should give your most of the time in developing something which is useful or which will be having an economical gain for institute or for yourself in future. So his experiments were a wild chase. The people used to criticize him, but you don't think if you are a researcher, you should not think if someone is giving you that this is not going to work. But at the end, we never know. You come up with a solution which is very beneficial to the society. His ideas were very new and different. So Captain Barbius night writing were based on a sound notation. So for a common people to understand, they have to, the blind people, they have to first learn the sound notations if they wanted to read something. So Lewis decided that why not this raised dot can be utilized for a letters, not for a sound. So that can be easily readable by the blind people. And even in French, only 26 letters were part of their all alphabets. So he invented a means of literary for a blind people using this different presentation for each alphabets or numbers or symbols. He continued his work for several years, and he developed code for number. And in 1827, you should appreciate that he born in 1809, and in 1827 he got a first book in a Braille code was published. And he didn't survive too long. At the age of 43, he passed away. And you can see that whatever he has invented at that period of time, the people are using after almost 2 centuries. So how beneficial that system he developed for the blind people. See, these modern patent laws were established during the period of 1883 in a Paris convention. So you see that he passed away in 1852, and that this patenting of modern patenting system came into existence in 1883. After the 30 years or so, he passed away. So that's the reason he doesn't have any patent. But he should have got patent if he invented at the latter of this Paris Convention Act. So we'll understand that a researcher, what we can learn from this Braille code as a researcher. So he followed his idea to develop a successful tool to read by blind people. He had a great open mind. See, he tried so much of experimental work. He got an idea from that captain that raised dot can be made. But having said that, it does require much of a tools like a stylus, which is very difficult to carry. And for the blind people, it's again a challenging to carry such kind of a tools, which are not that suitable for blind people. So he thought that he opened up his mind, and he took that whether this sound notation can be considered for alphabets. Perseverance to find and taste a solution. See, तुम्हाला चिकाटी हवी, काहीतरी तुम्हाला जर अप्रोच करायचं असेल, you should have a perseverance to find and solution which can be helpful. So time spent on experimenting, you should spend much of your time in experimenting. Since you are in a education role, you have a lot of time to do experimenting part. Once you are in the real life, you will have to give all outputs right away. You don't have much of a time. So think of if some failures also come during your learnings, that's okay. Until and unless you don't fail, you will not be successful. So think of this Braille as an example, how good researcher you can become. Diligence, you should be more aware that how that can be helpful, and you should be careful enough during your researching, so that it will be very helpful for all common people. This guy helped blind people. He provided a tool which they can read and write. So how important? After he passed away, people are still using his method. And even nowadays, people have a tabs or a printer which can print such kind of a braille code. Means after 2 centuries also, people are exploring how that can be helpful for blind people, that whatever he has invented almost 2 centuries before. The independence, it's a foremost, any invention gives you a freedom. For example, in today's scenario, Atmanirbhar we are talking about. So your research invention should also provide such kind of independence, like the Braille provided independence to this blind people, not being dependent on any other person for the help. We saw that what criteria a researcher should have through this case study. Now we will understand the basics of patenting. What criteria are there for needed for patenting. As you know that patent invention can be simple as a paperclip, or that is also a complicated one, a robot. So that a robot that people with a particular domain will understand that complexity, how much it is involved in that robot development. And it is also for us simple, like a paperclip that can be developed by a common person also. But having said that, they should meet certain conditions of patentability before that can be patented. What are those? First one is utility or industrial applicability. If you think in Louis Braille system, it was a brilliant idea, and he made a product by his hard work, having a system of dots used by blind for reading, writing, and printing books. And the second and foremost is novelty, meaning that invention must have a new characteristics. It should not be a part of any knowledge which is existed before. As I said, that he developed a new tool for blind peoples. Earlier, people had tried many things. They have tried raised letters, lowered letters, letters with a stone, letters with a string, letters of wax. See now, letters of wax, how it will survive in summer, because it will melt, and to carry something with such letters of stone and letters of wax, it's very challenging. And you can see that during that period of time, people even use letters of woods. And even that period, one person has found alphabets of pins. Pins, actually, this tool is used for blind people, and it is very dangerous that pins are used to read something for a blind people. They may get injured. So this Braille, he got an idea from this Captain Babier's night writing, which was based on a sound notation. And this Louis Braille developed a dot pattern for alphabet letters. So novelty aspect was definitely there. There was no art which was suggesting that such raised dots are known in before Louis Braille developed it. Now, the most challenging among all this criteria is inventive step or non-obviousness. As earlier lecture, you might have heard that territorial aspect. So inventive steps or non-obviousness is been evaluated depending on jurisdiction which you are. For example, in India, we have a criteria of technological advancement or economical significance, or both. These are the criteria which we use in while evaluating inventive step. For example, in US, they think in non-obviousness aspect, that it is not obvious to the person skilled in the art at the period of your filing. So these criteria change based on jurisdiction. For example, in Europe, Europe think in different approach. They think in problem solution approach. Whether that solution was known to the public or that that problem existed before, whether you are giving some different solution to the existing knowledge. So depending on jurisdiction, inventive steps, evaluation can change. And in case of Braille code, see this new characteristics of invention, definitely by novelty, you see that there is a new characteristic. And while in understanding this inventive or non-obviousness test, it should not be deduced by a person. Means that person who is working in that field, he should not come to that whatever invention you are providing. It should not be easily deduced by that particular person who is skilled in the art. So Louis Braille was not the first one who got the idea to help blind people. People have been working for hundreds of years to help blind people. So, as while explaining the novelty, that there are so many ways earlier people have tried to help the blind people, but the only tool which is being used today is Louis Braille, who has provided us a solution. Means for blind people, it's a very good means the way he has developed this tool. It is really helpful for blind people in today's scenario as well. And he is the person who has succeeded in great way. So we understand the researchers' approach and patenting criteria through this Louis case. Now we'll see that what are the parts or the contents in the patent are present. For example, it does have a bibliographic details. What are those? The patent authority. That means in which jurisdiction you has filed a patent application. That comes on the first page, that bibliographic details of the patent application. Document number, and you can see that in brackets there are few numbers. Those numbers are called as INID numbers. These are internationally agreed numbers for this bibliographic data, which was given by WIPO, and it is a kind of a standardized. All jurisdiction follows this number coding for bibliographic details. So that, for example, if you are seeing any patent application which is non-English, by seeing this number, you will understand, okay, this 10 number denotes to the patent authority or the document number which is given by that patent jurisdiction. And this dates plays a very important role in understanding or gaining this information from patent. Each number denotes a different kinds of date. 43 denotes on which date this the publication or the invention came into the public domain. Publication date is being denoted by 43. 22 is a kind of a filing date. Filing date actually changes. For example, you have a priority date. In India, you file some provisional application. That will be denoted with a number code 30. And the filing date, if you are using that priority application, using the Paris Convention, you will understand this all Paris and PCT in future slides. But just to give you a glimpse of it, how these numbers help. The priority from India, you entered into any other jurisdiction, the filing date will come when you file that complete specification in that jurisdiction. That is called as a 22. That number filing date will come as a 22 one. Whereas 30, when you have a first filing, provisional filing date in India, that will be denoted as a 30. So rest of the information, the title, it's kind of a very short indication in which the invention is all about. This assigning inventors, that who is the applicant or who invented this invention, that kind of information are also present in your bibliographic details. Now, in the last part is the class codes in the bibliographic. It's a kind of a bridge between bibliographic details and the technical information. So it's a like our librarians stock all books in a proper way. They give, see, for example, if you approach the librarian, the book which you wanted, immediately that librarian can find because he had classified all the books in proper way. The same way patent applications are also categorized using these class codes. they have a definition in place. Whatever invention are been filed, the examiner will give the class code to all inventions in a classified way. All inventions will be classified based on this class code. So the bibliographic, it will also have a technical information. What is your invention is all about. So as I said, a title is also part of a bibliography, but it comes under also a technical information. Abstract is a kind of a summary of invention, what this invention is all about. And description gives a clear cut information, what this invention, how it works. All these answers you get from description. The other part is claims. Claims gives a legal boundary to your invention. In patent application, the most important part is claims, which you get a protection for your invention. How and it has to be done, that is part of a description, but what is claimed, what the protection is for, it is defined in a claims part. And using these drawings and diagrams along with the description, you will understand the clear or concise information, how this invention and what is this invention is all about. So this is kind of a preliminary conclusion. I will be jumping into the latter slides also. So now we'll see the types of searches of patent information. So what are the types of searches? As I said that before going for any patent application, you should do your homework first. What is the state of art? Means the particular field which you are working, you should have hands-on information ready with you that that can give you a glimpse of what technologies existed before in that particular domain. Again, this landscape is also, it's a deeper analysis of state of the art, which is having with the graphical representation, and you will see that how technology is evolving over the period of time using this landscape and state of the art study. As I said, that patentability criteria, we have seen that utility, novelty, and inventive steps are very important for any patent invention to be protected. We should have this ready, patent searches ready before filing, so that there in future examiner cites you some documents. You should be ready enough that during that examination response, you can provide a justification to whatever there is objection raised by the examiner. So other searches are not that important, since this is a basic lecture on this patenting. So these are used when you are particularly working in this field. Validity searches are also kind of a patentability searches, but when the patent is been granted, to challenge those, we need to carry out this validity search. So FTO is also one of the search, which I don't think so it's the right time to understand that FTO, but only basic information what I can say, you should know that you are not infringing to someone else's patent. As I said in earlier slides, that in benefits, that if the publication is there in the public domain, you get to know that you are not jumping into anybody's claimed invention. So these FTO searches are carried out to identify such potential challenge claims that can hamper when you want to market your invention. And also this competitor intelligence and innovators and benchmarking searches are also part of it, but we'll skip, we will not go into much of the details. Steps prior to patenting, we have already discussed about it, we will formalize it over here. So you should have a technology landscape ready, state of the art search ready as a part of your strategy for filing any patent application. Patentability assessment, if you do, what benefit it will give? It will give you ready when the examiner cites some documents for that criteria which are required for patentability, such as novelty or inventive step. So when you do this homework before filing, you will know that such kind of challenges were raised by objections were raised by examiner. You have a pointers ready if you do before filing this patentability assessment also. And what will help? If something is there, you will generate more data to defend your application at the period of examination. And that data generation, what it will help? It will help in strategizing your filing. For example, if you see that you are developing a molecule, and you see that someone else has already filed that patent application over that particular molecule as a product claim. Now, you have developed a process which is not known before. So you should you have something which is interesting or the process which is more beneficial than the earlier known in the prior art. So you should go for patenting in that case. You will not have FTO, freedom to operate, to use that process, but definitely you will have a such process that can be used by the innovator. He can approach you if your process is much of a beneficial than the earlier one. So that licensing, as I said in planning part, that licensing, in licensing, out licensing, this can be also a part of your strategy. If you do this homework before filing your application, you can generate a data. You have a data points ready before someone else challenges you. So I already said that this data can be used as a defense during prosecution of your application if you do this patentability assessment before patent filing. It is not compulsory, you should do it, but being safer, on a safer side, you can do this homework before filing. And now we will understand about patent applications. See, I have given only 2 applications, but this is not the way. There are other kind of applications also. Those are other than this ordinary application and international application. For example, a divisional application. See, for any patent is been granted for single invention. You cannot club 2 invention and get a patent application granted. If examiner finds out that your application consists of 2 inventions, he will ask you to select one and consider for the next second invention for a divisional filing. So you will have to file the divisional filing for the second invention which you tried to get the patent application granted by clubbing it. So that's not possible. You will get a patent application granted for single invention. And another one is a patent of addition also. For example, you are working in some field. You developed a process, you filed a patent application. In future, you understand, okay, I got a much more beneficial process than this current one. So you can go for this patent of addition application before grant of patent of your application. Once it has been granted, you cannot file that patent of application. In US, those are called CIPs. That is also not possible. Before that patent application get granted for the parent one, you can file the patent of addition also. Now, these tools are not considered presenting over here because we'll be seeing a very basic application. What are the applications which are used by the patent applicant for filing? Ordinary application is in the particular jurisdiction you are entering. For example, in India, if you file as a priority application or a complete application, you will file as a ordinary application. There is other type of international application when someone else in other jurisdiction wanted to come in India. He will have to come through 2 routes: the Paris Convention route or a PCT route. Paris route is means suppose he filed his provisional application in his jurisdiction, for example, Europe. Not Europe, US. So within 12 months of period of time, he has to come into India for his with his complete specification for India filing. So you got only 12 months to enter into the national jurisdiction. The PCT route is more beneficial. It gives you 18 extra period of extra months to decide and strategize whether you should enter into that particular jurisdiction or not. Think of you're having a ordinary application today itself, and you wanted to enter into different jurisdiction, for example, Europe or US. So if you want to use a Paris Convention, So you will have to file a complete application within 12 months of period of time. And if you are using that PCT route gives you extra 18 months time. You will have to enter before 30 months of period. What it helps? It helps if the country which you are entering is non-English one. Your application has to be translated. So whatever the cost you will be incurring, that will be delayed. It will come into picture at the period of 30th month. So you will strategize whether you want to enter or not enter into that jurisdiction. This PCT will really help you in long run. So this is a kind of a patent life cycle. As you can see, it's a very clubbed one. We'll go step by step into each one. Filing a patent application. I told you what homework you should do. And now you are ready with your invention. Now there are two routes where the way you can enter. You can directly file a complete specification, which has the claims in your application as well. It gets published within 18 months. Other way, you file a provisional application. Provisional application, you get something very interesting, and you want to protect that idea right away without thinking of much of your drafting time and all. You file the provisional application without any claims part. But definitely you should have all embodiments ready to have a proper protection during the provisional applications only. Now, after provisional, you need to have a complete specification filed within 12 months of your provisional application. If you do, it will get published within 18 months from the provisional application date. If you don't do, your application is considered deemed to be abandoned. So your deadline starts the moment you file this provisional specification. Within 12 months, you have to file your complete specification. If you don't do so, your application is deemed to be abandoned. Now, after publication, anyone can file pre-grant opposition, and their objection can be a variety of objections which are given in Patent Act. This request for examination is also possible. You can expedite your examination. But having said that, you have to file examination request within 48 months from the first filing date. Either complete, if you go directly file a complete specification, or a provisional filing. Within 48 months, you need to file a request for examination into the patent office. If you don't do so, your application will again considered as an deemed to be abandoned. So examiner will not have examine your application, and he will treat that you are not interested to pursue your application which has been filed. So as I said, that during the criteria defining, that you should be ready with your all argument ready for defending your application. The examination will be carried out by the national jurisdiction, and they will give you the objections on which you have to revert, and that FER will be issued. On that, you will have to give a response within 6 months of period. This time varies depending on jurisdiction which you are. Since we are considering here as an Indian scenario, you will get a 6 months period of time to give your response with a proper argument to the objection raised by the examiner. So on filing your response, your application can be considered for issuance. There is a much of an amendments also has to file to satisfy all the criteria, like a novelty and inventive step. You need to you need to limit your invention in sometimes to satisfy all these criteria. And if there is also, if examiner is not satisfied, he will ask for a hearing. That you will get a last chance, not last chance, but a chance to defend your application at the time of hearing. That will have a one-to-one conversation with the examiner. So, for example, the objection raised were not overcome. What will happen? Again, your application deemed to be abandoned. objections overcome, whatever the objections were raised by examiner, if you satisfy all of them, your patent will be granted under Section 43 of Indian Patent Act. Now, again, grant of patent, does that mean that your job is done? No, you have to maintain that patent application after the grant of patent for the period of 20 years from the date of provisional filing. So every year you have to pay some fee. You can pay in the blanket also, 4 or 5 years altogether. That can be done, but every year there is a maintenance fee for granted patent to have a active that life of that patent. So now we will understand through this case study how this research plays an important role in developing that particular technology, and how that patenting helps that research to evolve in a better way. So now we'll see this molecule, this chlorantraniliprole. It's a diamide insecticide which was developed by DuPont in I think in 2001 around 2002 around. This molecule, most of the people, if they are from farming background, they will know this coragen. It's a formulation of using this chlorantraniliprole molecule. Farmers do know this coragen because DuPont has had done a branding in such a way that most of the farmer knows this coragen. But even though they don't know the active ingredient which is playing a part, but the branding is such a way that all farmers know this coragen. Now, see, the filing date of this particular molecule is in 2001. There are almost 60 patent applications in 2012 for this particular molecule. For particular that novel compounds, since as I said that patenting is all about strategizing the invention. For AI patent, the DuPont and others have filed almost 25 applications. And for processes, there are 17 different applications were proposed. For this particular molecule, even though the molecule was developed by DuPont, the BCS, the Bayer Crop Science, they are also majorly playing role in developing a better process, so that you can understand that others were also coming into picture, even though they don't have FTOs, but they do have this new patent application on process aspect, so that they can collaborate with the innovator and develop that route which is beneficial in economical or in either way, economical or technical way. And there are other patent applications which were based on formulation, mixture, and also animal health. Means there are different indications also have been filed for this patent application. And I'll suggest you read these two references. You will get the idea how this researching and patenting played a crucial role for this development of diamide portfolio. And this is it's a blockbuster molecule. It earns billion every year for DuPont, which is not at the moment part of DuPont. You will see that in next slide with whom that particular portfolio is now. Now, as I said, that researching is a continuous process. Now you can see that cintraniliprole. This is a new molecule which was developed by DuPont itself. During that period of time only, you can see that by changing chlorine to cyanide group, this cintraniliprole molecule gave a wide insecticidal spectrum, so that it can be used for multiple insects such as hemipteran pests such as Myzus persei or hoppers, means grasshoppers and such kind of insect can also be killed by this cintraniliprole molecule. Okay, you can understand that during this continuous process, even though DuPont was earning $1 billion using that chlorantraniliprole, but they didn't stop there. They wanted to have more and more advancement in that domain. So they bought this new molecule, which is having a broad insecticidal spectrum. And you will get much of this information in these two literature. I will share this at the end of session in the chat box. So as I said, this picture, many of you might have seen that knowledge, experience, and creativity, how the person design their strategy. Depending on that, even though if you have a knowledge, if you don't utilize your experience or creativity in a proper way, you will not lead into the successful entity. So think of that knowledge here. We will consider this dot as in patent filing. You will get the experience during all this strategizing this invention. So this creativity part, until and unless you don't strategize your invention in proper way, using this patenting or research development, so that you need to join the dots in a proper way to be a successful. Similar way, you should also think of the problem which you are solving, strategize it before any hurdles come down the line, such as examiner cites something which is not in favor of yours, if the FTO issues which you are not aware of, think before you launch any product into market. So being a researcher, you should understand research and patenting, how it goes all together. Now, as I said, this molecule was developed by DuPont. Now, in latter period of time, in this last decade, this big merger came into existence. Dow and DuPont came together. This diamide portfolio belongs to DuPont. Merger of Dow DuPont, what happened? This portfolio divestment has to be done. As I said in earlier slide, that policymaker also need to understand all this patent information. So what they do, this competition commission, it's a part of policy making. So to avoid monopoly, this diamide portfolio, they have to divest it to FMC. Now FMC is another industry working in the same crop protection. So the DuPont, it's a kind of a exchange. You give this, I will give this. So the DuPont acquired FMC's health nutrition with an additional cash transaction, and in return, FMC gave diamide portfolio, which we discussed, that it's a $1 billion portfolio. So FMC was not in the top 5 in this crop protection domain, but because of this merger followed by divestment, FMC got this diamide portfolio. Now they came into the top 5 global crop protection companies. So now, in concluding all of these slides, what we saw that this stock exchange of US, we saw that intangible assets were growing exponentially over the period of time, and this trend will be continued. So you need to be future ready. You need to understand this IP aspect right away itself. We saw that Humira portfolio, how that patenting strategies helped economical gain, how they got this economical gain in the continuous development of this Humira portfolio. IMAC is one of the public research institute, how their innovation ecosystem led to become a very successful entity. Use Braille, it's a gift given by him to the blind people for literacy. We saw that patent application, types of patent application, types of searches. And we saw this case study, DuPont strategy, and how that FMC gain, so that they studied all these patenting strategies of DuPont, and they their business team asked for, let's acquire this diamide portfolio, which is very beneficial for them in long run. With this, I conclude my session. Thank you.
Yeah, thank you very much, sir. Sir, it was a fantastic journey through the world of economics and finances of most of the multinational company, and how companies have become bigger and bigger with huge turnover with the help of intellectual property rights, particularly patents. You have shown us, particularly after 1995, why there has been a tremendous exponential growth in terms of revenue of companies with the help of these legal rights in their names. And then with the help of case studies, you try to make a point why patents are so important. So if India is to progress, obviously we need to pay more attention to the world of intellectual property rights, particularly to the world of patents. So patents can eventually make this country great again. We are a country of 130 crore plus people, but then when it comes to research and development, when it comes to intellectual property, when it comes to patents, we are not yet the beginners. So there is a great road to travel, and I thank you on behalf of Research Promotion Committee and IQAC for interacting with us. Now I hand over the mic to Donde sir for question answer session, and Sathe madam as well. Over to you, Donde sir.
Yes, sir. Am I audible?
Yes, sir.
Namaskar, Yevle sir. My question is related to polymerase chain reaction, RT-PCR. Now we are using for detection of COVID virus and many diagnostic applications. Now this PCR is developed by a scientist who was driving in his Honda Civic car in California, and he conceived that idea. But basically he has the process occurs in nature as an in vivo replication of DNA. So it was known to science that this is the way the DNA replication takes place. And then he conceived the idea of in vitro amplification of DNA. So in that matter, how come it was already known to the world as a natural process? It was discovered, and then how come he got the patent for PCR?
Okay, this particular, I don't have any idea that in which jurisdiction you are talking about, where you got this patent application granted. If you could let me know, because it depends again jurisdiction by jurisdiction. In India, I don't think so, because I not gone through this case, so that I cannot comment very precisely. Because there are much of non-patenting criteria available in India in section 3 and 4. So I don't know this, because this particular technology and how whether you are talking about in India itself. In US, yes, there is a possibility, but someone has to prove their they have to overcome
it has a US patent. The PCR is has a US patent. Okay,
but whether it has been granted, I doubt so, because I don't.
No. He was working in a Cetus Corporation. He was an employee of that, and they sold it to other person, and from that the PCR machines was developed.
Okay, so maybe in application phase, but we need to go understand that once the examination gets over, so that picture will be clear whether they will be considering. Obviously, they will have to satisfy all these criteria. Along with that, there are statutory requirements of national jurisdiction, like we have in section 3 and 4, what are not patentable invention. Similarly, in US also, there are few statutory requirements they have to overcome to get the patent get granted.
Okay. My next question is whether the Humaria portfolio is it not a case of discovering the new role for the same drug which was discovered, like a repurposing of drug? Is it not the same?
Of course, it's a kind of a repurposing only. But since this is kind of an orphan drug and it's a monoclonal antibodies, so earlier it was for arthritis. Now you can see that the people are having indication in skin treatment as well.
Okay.
So it's repurposing only.
But the earlier presenter said that the drug which is repurposed cannot be patented. When I asked same question to the earlier this one, madam said that it cannot be. Once we have patent for one particular drug, and if the drug is repurposed for some other disease, then we cannot have patent for that.
Yes, that's what. See, I will make it clear. So it again depends on jurisdiction. In India, new use cannot be patented. So madam referred to that Indian scenario. Whereas in US, this new use and multiple jurisdiction, new use has been patentable. So again, that statutory requirement has to be satisfied if you want to get a patent. So in US, it's allowed, but in India, that's not possible.
Okay, so there is a question from Dr. B.K. Sonamani who asked this question for first session, but I found it relevant to this session, so that I'm asking his question. What is the procedure to apply for patent in case of research outcome in the field of science and technology? I think it's a very general question, but still I feel that what is the procedure to apply for patent in case of research outcome in the field of science and technology?
So these are all about science and development only. I explained in detail what are the process we need to, means whether you are going for provisional application or direct complete application, all these steps has to be carried out. Then only your application will turn into the granted patent. So if you are talking about domain, of course, it has a multiple steps to derive it. First of all, you need to draft a patent application, which can be held by any patent agent or attorney to have a proper, you can do it on your own, but patent agent is a person who can deal with the patent office. He can be a mediator between you and patent office. So you need to take a help of the patent agent or patent attorney to have broadening your invention, so that sometimes you will find something you will protect if you don't take any help of expert in that field. So you need to take a help of any agent or attorney to have your patent in a better way, in a protection in a better way.
Okay, thank you, sir. Now for next remaining question, I over to Sathe madam.
Thank you, Donde sir. Thank you, Niranjan sir. It was very informative session for us. The question is, now you said it is patenting is important for all of us, isn't it? For research and all that. As our countries depend on the farmers, mostly on the farmers. So is there any channel to patent them, whatever they have invented in a simple way? Maybe in the farming, you are day to day, they are doing some work. So is there any channel or is any agent who can help them to do all these things?
So again, farming part. So farmers generally, if they develop a new species, so that is not a patentable subject matter in India. There is different act for plant variety protection, which is not part in this patent domain. It comes as a variety protection if they develop something new out of it. So they have to deposit into the Variety Act PVPRP. So it's not part of patenting, but yes, if you develop a new species, that can be protected in that act.
Or any method they will develop for post harvesting?
Again, as I said, in India, there are multiple non-patentable inventions. These agricultural and horticultural methods are also not part of patenting. Being otherwise, it will not solve the purpose of working for common people.
Okay. Sir, one more question. Is there any standard fees regarding this?
For patent application?
Patenting application.
Yes. So again, fees part, it varies. For example, if a natural person, a solo inventor files a patent application, he has to pay 1,600 rupees if we do it online filing. If we do it physical filing, he has to pay extra 10% of it, so that it goes around 1,750, 60 rupees for application part. This application only fee for application. And if you are not a natural person, if you are a small entity, SMEs, so you have to pay almost 2.5 times of 1,600, so that it's like a 4,000 rupees for patent application. And if you are a big company, you will have to pay five times of the person who is paying as a natural person. So it's like 8,000 you have to pay while patent application.
For any type of patenting?
Yes. Only any type of patent application. Means it depends on applicant, how much fee you have to pay. And this is only a first fee. There are followed up fees. Request for examination. Again, you will have to pay a few more bucks. So it's like, I think 12,000 odd fees is there for request for examination. Again, even if you have a granted patent, to maintain again, you will have to pay fee. So every year you have to pay fee. So it's a fees comes into picture every time here and there.
Okay. Then one more question, sir. When we are filing this patenting, that is, and once it will expire, can we repatent for the same?
No, see, you will not satisfy in that say novelty aspect, because whatever the information is there in the public domain, if you file something over it, you will your own filing will come into picture for novelty. You need to overcome that novelty aspect.
Okay. Okay. There is one more question from Matthew, sir.
Yeah, one more point to add. If you develop something new out of it, definitely you can have a patent.
Okay. Okay. One more question, sir. Different countries have different patent laws, but do they collaborate on patent laws?
And see, as I said, these three criteria: novelty, inventive step, and utility. These are common in all jurisdiction.
Okay.
Which and few of them were designed by TRIPS agreement, but there are statutory requirement which was defined as per the country's need. For example, in India, we have so much of invention which are not patentable. The similar way, the US have lesser restrictions, but they also do have some of the statutory requirement based on their demand or their philosophy.
Okay. One more question related to what you have taken that example, Braille Lipi. Is there any other way of communication other than the Braille?
For blind people, it's the only way the people are mostly using it. As I said earlier, people used to have much of more different or difficult tools for reading. Nowadays, people are using, even printers are available for Braille Lipi so that they can print. We have our normal laser jet, so it raised dots comes through that printer itself. So it's kind of a more helpful for blind people, since it has a multiple alphabet based system. So it's I don't think so other that may be available, which I may not be aware of at the moment, but this is the most successful one as I can comment on it.
Okay, thank you very much, sir. Now this question answer session is over. Over to Joshi sir.
Okay, thank you, madam. Thank you, Donde sir, and thank you, Yevle sir. May I now call upon Dr. Patgaonkar to propose formal vote of thanks to Yevle sir. Patgaonkar, madam.
Yes. Thank you very much, Dr. Yevle sir. First, for accepting our invitation, and second, for delivering such an insightful discourse on patenting. Really wonderful explanation. Sir, on behalf of RPC and IQAC of Kirti College, I express gratitude to you. Thank you.
Thank you very much
for letting me part of
madam. And thank you, Yevle sir. Okay, now we move on.
I'll be leaving then. Okay. Thank you.
Yes, sir. Thank you very much. Yeah. Thank you for sparing your time, valuable time. Thank you. Yeah. Now we move on to the final session of the day, and the next speaker is Miss Nupur Goyal. May I request our senior faculty in the Department of Chemistry, Dr. D.V. Patil, to introduce Miss Nupur Goyal. Patil, sir.
Good afternoon. Am I audible?
Yes, sir. Little louder, please.
Thank you. Good afternoon to all dignitaries and participants for their valuable presence for today's national webinar on intellectual property rights. What researchers need to know. I, Dr. D.V. Patil, an associate professor from the Department of Chemistry, Kirti College, have been granted precious duty to introduce an eminent resource person, Ms. Nupur Goyal, Madam. Madam Advocate Nupur Goyal is the founder member of Human IP Consultancy Services, which is an Indian IP consultancy organization. She has more than 15 years of experience in intellectual property rights. Basically, Nupur Madam is a qualified microbiologist. By merit, she was gold medalist. She is a qualified IPR scientist under WOSC category, that is Woman Scientist, now recognized as Kiran IPR of Department of Science and Technology, that is DST, Government of India, implemented by Technology Information Forecasting and Assessment Council. TIFSC DST. Nupur Madam is an IPR trainer certified by State Project Directorate, Rashtriya Uchchatar Shiksha Abhiyan, that is RUSA, Ministry of Human Resource and Development, that is MHRD Maharashtra, as well as Rajiv Gandhi National Institute of Intellectual Property Management, Nagpur, Maharashtra, Ministry of Commerce and Industry. She is regularly invited as a guest speaker by several government organizations as well as private institutions. Before gaining experience in IP, she was involved into research activities in microbiology with several achievements to her credit. Being a researcher herself, she has an edge over other fellow members of IP fraternity working in the same domain. With this brief introduction, I request Nupur Madam to take charge of the session 3, that is trademark and geographical indicator. Over to Nupur Madam.
Nupur Madam?
Yeah. Hello, am I audible?
Yes, Madam.
Okay. I'll start sharing the screen first.
Yeah.
Please confirm if it's visible clearly.
Okay.
Is it visible?
Yes.
Not yet, madam. Now, yes.
Present.
Yes or no, please? Is it visible?
Presentation. Have you shared your presentation?
Madam, we can see only the blank screen.
Okay, just wait. I'll reshare.
Yes, yes. Trademarks.
Is it clearly visible now?
Yes, madam. Yes. Trademarks.
Okay. Am I audible properly?
Yes, madam.
So, namaste and good afternoon to all. First of all, I would like to extend my acknowledgement and appreciation to the organizers of this national webinar on IPR, and a special thanks to Dr. Jitendra Mahajan, who was instrumental in coordinating with me and who extended the invite to me. So thanks to each one of you. Since morning today, we have been listening about IPR and how the academicians and the researchers can integrate their research work or their core work with the IP. So we are now in 2021. It's April of 2021. So first of all, let me ask from each one of you, do we really think that we are yet not aware of IP? Do we still believe that IP is something which we have so far not heard of? The plain or the clear answer to this question would be no, because right from the morning when we wake up till the time in the night when we go back to our bed again, we all are surrounded on a day-to-day basis with one or the other forms of IP. How? Let me give you a brief example. The moment we wake up, these days we all carry smartphones with us, and so we have the habit of checking our phone immediately the moment we wake up. Or even nowadays, we set up the alarm in our mobile phones. What is a smartphone? It's we either purchase it from, say, brands like Samsung, Oppo, Vivo, Apple. What are these company names? These are the trade names. And what are the trade names? The brand names. This is one form of IPR, which comes under the category of trademarks or the trade names. Again, the moment you step inside the washroom, you use different kind of deodorant, bathing soap, detergent, shampoo, provided by one or the other company, FMCG company like Procter & Gamble or Hindustan Unilever Limited. Even by seeing the shape of the bottle of your shampoo, you can clearly recognize as to which company it comes from. Again, the moment you step for your breakfast, you would have either the Quaker Oats or the Kellogg's cornflakes, butter by Amul or milk by Amul, or the curd by Amul. Again, what is that? Again, another form of IPR. That is the trading or the trademarks. Then let's go back to our childhood time. Since our childhood, we have been explained to use the book, to read the book. The moment you catch hold of any of the book and you simply turn the first page thereof, you would see before the page preceding the preface of the book, you would see a C written within a circle, or sometimes it would be written copyright clearly over there along with the year of the publication. So what's that? Copyright is another form of IPR. So in short, I intend to say that though we are in 2021, we all have been familiarized with IP since ages or since our childhood, but it's just that we have never correlated with the clear concept of it. We haven't integrated with it. We haven't associated ourselves the way we should actually have been taught for it. That's the reason I always mention this, that the time has come that the education system of our country needs to evolve, needs to change, and in one or the other form, at least a paper, at least a subject of IP should also be taught to the students, right from the beginning, because otherwise, right now, the audience, most of the audience on this platform today are from the research background. They are probably the PhD students or the master students, postgraduate students. So one fine day, after pursuing so much of your coursework and completing everything, if you are told about IP, then you can't, the brain just cannot correlate it with it directly, because the brain, the way our brain is conditioned, we have all been taught of the gradual transformation of the brain. The brain has the habit of learning or adapting to things gradually, and things just can't happen to our brain. Our brain can't evolve overnight. So the gradual transformation is missing, and that's the reason this gap has extended to such an extent that nowadays such a lot of hue and cry is being created about IP, creating awareness of IP, especially about after the formulation of the national IPR policy in 2016 by the Modi government. And also after so much of programs have been conducted by the government, and so many amendments are being carried out, even CPAM is a body which has been formulated by the government, so that training program or the awareness program for the students are being conducted in the schools. Obviously, prior to pandemic, this COVID pandemic, it was conducted in physical mode. Nowadays, it is being conducted in the online or the virtual mode. Why I'm sharing all these background is the reason, so that you can, because today you are listening or you are hearing about so much about IP at a stretch. So you may not be able, you may not be able to capture or grasp each and everything in totality. But if I'll share the background with you, then definitely the next moment when you will catch hold of any of the book or any novel or any research article, then you will definitely get to see the C written within a circle, and you would get to understand that, oh, this is also a form of IPR, or the trade names or the trademarks. Also, you would start relating to it on a day-to-day basis. So the speakers have already mentioned a lot in detail about the various forms of IP, especially Dr. Mridula Bele has touched upon various forms. And now I am supposed to take in detail about two forms of IPR, that is trademarks and the geographical indications. Before I start speaking in detail on these two forms of IPR, because the audience is mostly from the research background, and obviously the future generation is also here, I would like to share with you a few future prospect or the career aspect in IPR. See, as a researcher or as a science person, you have the opportunity to appear for patent agent examination that is conducted by Ministry of Commerce and Industry. You can see for its notification in the employment newspaper or on their website, which is the www.ipindia.nic.in. The basic requirement for this, the eligibility criteria for appearing for this examination is that you should be a citizen of India. You should have attained 21 years of age at least. You should have pursued your graduation in either science or technology, and you should be of sound mind, and you should not have been convicted by any court of law in our country. This is the basic requirement. And the format of the examination is that you need to respond to the questions. They don't ask anything from your core domain, that is the technical domain. The entire syllabus is from the Patents Act, which is the law governing the patents. The moment you would try to research or to know, make yourself aware of what is patents, you would get to know, and you would get the previous year question papers also on the website. So that would give you a glimpse and idea as to how to take about that examination if you are really interested, because that examination will provide you the way Dr. Niranjan Yevle has already also said, that the moment you add the aspect of IP in your resume, it gives you an edge over others. So try to inculcate that in your resume. And if you are a non-science graduate, then you can appear for the trademark agent examination that is again conducted by Ministry of Commerce and Industry. Basically, the trademark registry conducts that examination. Again, the notification can be obtained from either the employment newspaper or from the same website, that is ipindia.nic.in. If you are advocate, if you have pursued your LLB, then definitely you can automatically you can handle the trademarks or the copyright matters. So with this now, with this background, with this information, I would now start delivering the session on trademarks. So what is a trademark? In basic parlance, in a general parlance, I would like to express it the way each one of us have been given a name. And we all know that name functions as an identifier. The way people call me Nupur, my parents gave me that name. Likewise, to you, your parents or others have given you the name, and the name functions as an identifier. Similarly, the trademark helps as an identifier. It helps in identifying the source of a product or service, and it also helps in relating and establishing a correlation between the quality of the products, and it helps in distinguishing the product from others or the other company's products or goods or the services. The way if someone would call me by name Nupur and there are 10 other girls, definitely I would be the one who would respond. Likewise, if you go to the market and if you are purchasing a product, the moment you see a tick mark, a swoosh symbol, you identify it as a Nike product. How does that happen? There is no mention of the word Nike that from used by the letters Nike, but you get to understand. Or the moment you see the arch M of McDonald's written in yellow, you get to understand that it is a McDonald's. How does that happen? So a trademark is such which helps in identifying, and therefore we say that trademark helps in advertising and it helps in creating brand loyalty. This is a famous phrase by William Shakespeare. He used it in his famous play Romeo and Juliet. What's in a name? That which we call a rose by any other name would smell as sweet. However, when it comes to a trademark, in Hindi we can say naam mein kya rakha hai. But then when it comes to a trade name or a trademark, then a lot is there in a name. A trade name, a trademark holds a lot in itself. So if William Shakespeare was alive today, or even if at that time when he wrote these lines in his famous play, if he was aware of the fact that a name would be sold off or a name would hold a value in say trillions or billions of dollars or euros, then definitely he would not have written, I believe he would not have written this phrase, that which we call a rose by any other name would smell as sweet. So what is a trademark? Dr. Bailey has touched upon this, that a trademark could be either a word, a symbol, a device, a slogan, a product packaging, or a shape, which clearly identifies the source of a specific product or service and distinguishes it from others in the marketplace. So For example, we can see Cadbury or the word Toyota. It is a trademark. The Mercedes symbol or the Audi, the four rings intermingled with each other. Or the Starbucks, this TM is written over there. Just do it. The moment we read just do it, we get to understand that it is the slogan of Nike. Or for LIC in India, their slogan, the famous slogan, Zindagi ke saath bhi, zindagi ke baad bhi. It was initially their slogan, but now I think they have changed their slogan to Har Pal Aapke Saath. So the moment we get to hear about these, we are able to relate to the company or to the service provider. So that's what the function of a trademark is. A trademark in general, it would include a device, a brand, a heading, a label, a ticket, name, signature, word, letter, or numeral, shape, packaging, or any combination of the above. So when you as a, either if you are working in a company or as an attorney, if you have to advise to your client, or if you are working with a company in the capacity of a legal advisor, then the way the trademark is coined, you have to think of combining either in, so you can use it as a solo, the way swoosh symbol or the arch of M, the arch M is used for McDonald's. You can use it alone or you can use in any combination. On the top right hand corner of this particular slide, I have used an image which says Lux, Surf Excel, Lifebuoy, Wheel, Lakme, Pepsodent, Brew, Vim, etc. Red Label. So I'm sure, pretty sure that most of you would clearly relate that these FMCG products, that is fast moving consumer goods, these belong to the company Hindustan Unilever Limited. Though there is no mention on this particular representation, on this particular image, there is no mention of the words Hindustan Unilever Limited. Despite that, you would be able to clearly relate to the company which caters these products. Then again, there you would see another image, which is blue stripes alternating with the white stripes. I am sure again that many of you would relate it with the missionary which was started by Mother Teresa. They have got a trademark over this. In general, when a trademark application for when it is pending, that means the registration is yet to be sought on it. You have the right to start. You get the right to start writing T, capital T and capital M underneath or either as a superscript or a subscript adjacent to your mark, the letters T and M, to indicate that there is a pending application for registration of a trademark. And the moment the mark gets registered, you can start writing capital R within a circle. That clearly designates that the mark is registered. So now, how do you select a trademark? What are the criteria which you should think of, or what are the basic tenets which you should keep in mind when you think of coining a trademark or assigning a mark to any of the logo, or how do you design it, how do you frame it, how do you think of it? It should be, these are the few suggestions which you should think of, which anyone who is working in that particular domain should think of, should keep in mind that it should be arbitrary. Arbitrary meaning thereby, for example, we have seen when the moment we see a half-bitten apple, we clearly relate it to the Apple company. We do not consider it to be an edible apple, but we consider it to be a brand name belonging to the company Apple. So that's how arbitrary mark is coined. Invented, again, the way Kodak word is, it is an invented mark. Or the Xerox. Xerox is an again invented mark. You won't find its mention in any of the dictionary. It should be, the mark should be easy to spell. It should be easy to pronounce. It should be easy to remember. It should be easy to recognize. The basic thing is that the mark should not describe it on itself. The mark is not supposed to describe the product or the services, or the mark should not talk about itself. The mark should be distinctive. The more distinctive the mark is, the greater the chances are of its registrability. And the mark should not be laudatory, meaning thereby that the mark should not boast of itself, or should not appreciate itself, should not keep on going to speak on itself. And the major fact which should be kept in mind is that the mark should be such that it should avoid the linguistic traps. What do I mean by this? The linguistic traps means the way we all know that the Coca-Cola company, the Coca-Cola drink which we all consume, and which we all relish so much, it's not only sold in India, whereas it is sold all across the world, all across the globe. So the same Coca-Cola word cannot be, not all countries are English speaking countries. So if the similar word is used in different language, the meaning should be the same. For example, when the Coca-Cola, they were thinking of coming up with a mark, they had already printed a lot of the publishing, the advertising material using the Chinese resembling characters. That was Kekau Kela, that is K-E-K-O-U, K-E and L-E. So it was phonetically similar, sounding similar. However, they missed on something, that in Chinese, the meaning of the Kekau Kela was bite the wax tadpole, or a horse stuffed with wax. So imagine if they had continued advertising with those expression, with those letters, with those words, then definitely the product would not have sold in that market. It was only after they had published a lot of material that they got to know that there is some discrepancy and they would be trapped in this particular linguistic issue. So then they researched a lot, and then they researched around about 40,000 Chinese characters, and then they found a resembling, again a phonetically similar words, that is Kekau Kola, that is K-O-U-K-O-L-E, which means let the mouth rejoice, and the or rendering happiness in the mouth. So, and Coca-Cola, what it actually means, it also means delicious happiness, or the let the mouth rejoice. So that's how the company, big companies or the big shots, they have to think of when they think of selecting a trademark. Another example, Kentucky Fried Chicken, that is KFC. What's their trademark, or what the slogan is? Finger licking good. But again in Chinese, it meant eat your fingers off. So they had to think of another trademark, and they could not float the same slogan there in China. Another example I could share with you is some time ago, a few years ago, there was a car manufactured by the company Ford. It was with the name of Punto. But in Brazil, what happened, in Brazilian language, the word Punto or the Pinto, it is a slang. So none of the cars was selling, and when it so happened that they were not able to sell even a single car, then they realized that there is a linguistic issue, and then they changed the name to Korsel. Korsel means horse over there. So that's how when a trademark is coined, these factors or the linguistic issue has also to be taken into consideration. How a trademark is selected? This is the distinctiveness spectrum. The more generic a mark is, the least chances are of its registration. So because the more generic the mark is, it would be less distinctive, and therefore the chances of its registrability is pretty low. And the more fanciful, the more arbitrary the mark is, it would become more distinctive than the others, meaning thereby the less generic it is, more distinctive it would automatically become. So the more distinctive the mark is, the better it would be its level of protectability. Generic marks are definitely not able to get trademark protection. Descriptive marks, however, the way, for example, a descriptive mark for airport services or for parking services at airports, suppose if they flash start saying park and fly, that would be very descriptive of their service, because they are simply saying come park your car and then you can take your flight and fly away. So that is very descriptive. However, descriptive marks also find acceptance only when they can show that they have acquired a secondary meaning over a period of time. One of the basic differences between a trademark and a trade name or a business name is, again, the classical example of the Coca-Cola. A trade name or the business name, it identifies a company or business For example, the Coca-Cola company, whereas the Coca-Cola, it is the trademark of the company, the Coca-Cola company. It identifies the source or the goods or the service of that particular company. This was a general introduction or the general information about the trademark. There are different types of trademark, and which I'm sure you all would have come across at some point of time in your life. The other form is the collective trademark. So what is the meaning and definition or the explanation of the collective trademark? Let's see in this particular slide. Collective trademark, it is owned by an association of person. It does not belong to any single person. However, every person of that particular association is permitted to use that particular mark. The way you would see a C and A written at the bottom right hand corner of this particular slide. This is the collective trademark owned by the Chartered Accountants Association. So every chartered accountant, whosoever is member of this Chartered Accountant Association, is permitted to use this particular logo, this particular mark as the trademark. Likewise for the Reliance, this particular R. So what is the difference between collective trademark and the general? Collective trademarks are exception to the underlying principle of a trademark, in that the trademarks serve as the badges of the origin, as we have already discussed, that it helps in identifying the source or the origin of the goods or the service, whereas the collective trademarks, they indicate the individual source of the goods or the service. A collective trademark can be used by a variety of traders rather than an individual person, and it does not, the collective trademark does not belong. The owner would never be a single person. It would always be the association which has got registration on that particular mark. Another mark which we have already, which I'm again sure that each one of us would have come across at some point of time in our life, is the certification mark, like the ISI mark or the ISO mark or the FPO or the egg mark or the wool mark company, this particular mark. We all have seen these marks, but the missing factor is that we do not relate to it. So that the missing element has to be bridged now. We need to become more aware of the surroundings. We need to get in that mindset of a child, the way a child has the habit of asking so many questions, like तोता उड़ता क्यों है, तोता हरा क्यों है, कौवा काला क्यों है, आसमान नीला क्यों है, बादल काला क्यों है. As a child, we all have that habit of asking so many questions, but then the moment we grow up, we all have got into a typical kind of life. We are leading a monotonous kind of life, and we have missed that element of becoming inquisitive, becoming curious, of keeping on asking a number of questions. So that I believe that the moment we would again step back in the shoe of a child, and we would, as Indra Nooyi long back she said, remain a lifelong child. So I also repeat the same, that remain a lifelong child. And the moment you would again become a child, you would have that curiosity, you would become that inquisitive, and you would ask a hell lot of questions from you. And these days, this is the age of internet, this is the age of data. We have so much of information available at fingertip. We are carrying smartphones which have internet connection 24/7 with us. So whatever information you want, it's just that we have to do that extra bit from our part, and probably we would be able to bridge the gap. So the wool mark company, this is the certification mark which is used by the company, and this can be used by anyone whosoever certifies that particular, or whosoever complies with the requirements set by that particular certifying authority. Example, the wool mark company. So collective trademarks may be used by particular members of the organization which owns them, while certification marks may be used by anybody who complies with the standards defined by the owner of the particular certification mark. For example, the ISO mark or the ISI mark. So now let's see a couple of interesting trademarks, and the idea behind sharing these images is to make you understand, or to show you the kind of creativity, the kind of brain, the kind of intelligence which is used even while coining, or even while thinking of coming up with different kind of trademarks, in order to in an attempt of making it distinctive. We all know Amazon is the leader in e-commerce platform today. So Amazon.com, we all have seen that there is an arrow from A to Z, which means that Amazon has everything from A to Z under their umbrella. So that is an indicative of their services or which they intend to provide without even uttering that. So this makes them distinctive, and so the registrability and so the protection gets higher. Again, FedEx, we know that it is a logistics company. I am sure you would be able to see a white arrow moving from E to X. If you could see that, this is the arrow from E to X, which means express. Express as in, an arrow indicates that the express service of this particular logistic company. The way arrow, when you shoot it goes in a fraction of second or in a fraction of time. So that's how they mean to say that their service is also so quick. They're so quick in delivering your product to the other person. This La Tour de France, this is a famous bike race which have got their logo as such. If you would see it closely, you would understand that this R which is written, it indicates the racer, the rider of the bike race, and the O and this particular yellow O, again this indicates the rear and the front wheel, and the U of the tour, it indicates the seat on which the rider is seated. So see the creativity, see the kind of imagination which the person whosoever has come up with this particular logo, how much he has thought of integrating so many elements together in one particular logo. Baskin-Robbins, we all relish the ice cream provided by the Baskin-Robbins. So the pink the B and R, which is written, the section of B and R, which is written in pink, it indicates 30 wonderful flavors which is provided by them. So again, we all have seen, but I'm sure many of you would have related to it, many of you would not have. So that's the kind of imagination, that's the kind of brain which gets behind the framing or the coining of a mark, or which gets behind when it comes to making of a logo. Then Tostitos, again you can see two different I, which indicates two different people. The T indicating two different people, and the I is it could be seen as a table and on which a bowl of salsa is kept between two persons, and they are either sharing or fighting over it. Whatsoever you want, you can clearly interpret it according to your choice. This is an image of a zoo at Pittsburgh. I'm sure you would be able to see in white a lioness and a gorilla facing each other from left to right. A gorilla and a lioness. Can you see that? It's written over there that awesome. I definitely find it to be very awesome and very interesting. What a great logo to represent the logo or the image for a zoo. So when we have seen these clearly, it would again indicate that the more distinctive the mark is, the greater would be the level of its legal protectability or the registrability. So what's the function of trademark, and how a trademark should be used, and why should it be used? So a trademark, basically, it helps in cementing loyalty, brand loyalty. It helps in creating brand loyalty. It helps in binding the consumers with the products. You would have, I'm sure many of you would be fond of one or the other product, and you would never change. You never think of changing that particular brand. So that's the function a trademark helps in creating. I only consume Amul butter. I never prefer consuming any other product. And we all know that girl, or which is the logo of that Amul company. So a trademark, it helps in increasing the profitability of the company. It helps in responding to unfair competition. It helps in introducing new product lines, the way we have seen with the example of Hindustan Unilever. The company name remains the same, that is in Hindustan Unilever, but but they portray, but they convey their different products or the different services with different marks, with different images in when it comes to different product core lines. For example, Brew is for the coffee, or Pantene is for the shampoo. So there are different trademarks, but the name of the company remains the same. That is the Hindustan Unilever Limited. So it helps in introducing the new product lines also. It helps in gaining royalties through licensing. Dr. Bele has already mentioned to you that the way anything which you can do with the with your tangible property, your physical property. Similarly, any such thing, any such act would be you could clearly do with the intangible property also. You can sell it, you can license it, you can mortgage it, you can trade it, you can sell it off. Anything, any single act, and also you can pass it on to your legal heirs by way of succession. So this is also a property, and it functions similar to the tangible property. The only factor remains that it is intangible. You just can't measure it, as she has already told you. So trademark, again, it justifies corporate valuation. Many a times it happens that when there are mergers between two big companies, because a trademark helps in establishing goodwill. And a goodwill also matters a lot. A goodwill is also valued in billions and trillions. So it's the choice of the company whether they desire to sell the trademark, or they don't. Or they do not desire to sell their trademark, or they do not desire to sell or license their goodwill. So it helps in it really helps in financial transactions also. It also helps in maintaining and expanding the market share. So now we have seen in brief in what a trademark is, what is its function. Now, when it comes to Indian trademarks law, let's see how a trademark is classified and how a trademark application is submitted before the Indian Trademarks Registry. For patents, there is a classification which is governed by International Patent Classification. It's known as IPC. With respect to trademark, again, there is a classification. It is governed by the Nice Agreement, and the classification which we follow is the Nice classification. It's spelled out as NICE, whereas it's pronounced as Nice because it's a French word, and Nice is a place in France where the agreement was signed, and so it is known as the Nice classification. Trademark any trademark can be registered under class 1 to 45. From class 1 to class 34, it is the goods classes. That means the goods would fall under those classes. And from class 35 to class 45, the service classes begin. So this is in a couple of slides, I have tried to capture the essence of the classification, and an exemplary representation is given to give you an idea as to what each particular class contains, which good or which services does it cater to. For example, class 1, it belongs to it consists of the chemicals. So if you're thinking of if your product is such, if it belongs to the category of chemicals, then you will have to apply for your application under class 1 of the Nice classification. Likewise, class 9 for scientific instruments, class 8 for hand tools, class 10 for the medical equipments, class 5 for pharmaceuticals, class 12 for vehicles, class 13 for firearms, and likewise. For class 25, for example, it's the entire description of class 25 says clothing, footwear, and headgear. So again, a piece of information for you all. There was a judgment by Delhi High Court some time ago, and this court said that the description should not, you are not supposed to write the broad description. You should, because clothing is a very broad terminology, a very broad expression, and if you are thinking of coming up with an outlet of selling, say, ladies' suit, then that would definitely fall under the broad umbrella of clothing. But then you will have to describe it in a specific manner in order to indicate what all products do you intend to market or intend to trade or intend to sell under your particular logo which you have created, or the mark or the trade name which you have thought of. So that would help in that, and why the court has delivered such a judgment, because in case of infringement, it gets very difficult to ascertain, because if you write broadly, then definitely the court would ask you, you are not selling, you are not trading everything whatsoever comes under the ambit of the expression clothing. So how to differentiate your products with that of your competitor or with that of the infringer? So that's the idea behind. And so when you are applying for your application before the trademark registry, you should think of writing the description of the goods or the services very clearly and specifically. So as I had mentioned, that class 34 till class 34, the product classes are there, and from class 35 to 45, the service class begins. So advertising or communication, it would fall under 35 or 38. Insurance services, it would fall under class 36. Legal services or the personal services, it would fall under class 45. So that was the brief information about the trademark classification. Now, when it comes to the how do you think of, the way Dr. Niranjan Gyori has told you that prior to thinking of filing of a patent application, you should conduct a search, a prior art search, so that you do not reinvent the wheel. Similarly, you should also think of conducting a trademark availability search when it comes to the trademark, because if you won't conduct the search, then you may apply for someone else's mark, which probably might already be existing. So why to waste your money? Why to waste your time? Why to waste the resources? It is always advisable that go for a trademark availability search. You can do it on the Indian Trademarks Registry website, or and because trademark and trade names are correlated, are interrelated, so you should also conduct a search on the Ministry of Corporate Affairs website. So in order to ensure that there is no company name existing with the trademark, with the mark, with the same name for which probably you are thinking of filing a trademark application. Otherwise, you would be in trouble, because the moment you would apply for your application, they would think of opposing it. So you would be trapped in a legal issue. So the better thing is that you conduct a trademark availability search prior to filing the application. And these days, because it is the time of the internet era and e-commerce platforms, so you should also conduct a domain name search, because the way we have seen Amazon.com, so they are using it for everything. They are using it online, in online mode. You cannot take the same name and say you would come up with the same company name and you would start using the same company name. So you should also think of conducting a search for the domain name also. Now let's see that there are different trademark offices established in our country. There are 5 different offices, the head office being in the Mumbai. There is one more office for the trademark registry, that is at Ahmedabad. For patents, we have 4 offices, that is at Kolkata, Delhi, Chennai, and Mumbai. But for trademarks, there is one more office at Ahmedabad. How is a jurisdiction for a trademark determined? Meaning thereby that you being the applicant, if you are thinking of filing of a trademark application, then before which of these offices should you file the application? So that's what jurisdiction means over there. So jurisdiction is determined by the principal place of business in India of the applicant. So where your principal or the registered address of the business is, that would determine the jurisdiction of the applicant. For example, if you are in Mumbai, so the Mumbai registry would be the your jurisdiction. If it is a joint applicant scenario, meaning thereby if one business is in your name and you are based in Mumbai, the other one is based in UP, then the name whose name comes first, then the jurisdiction would be determined on the basis of the first applicant. And if it is in case of the foreign applicants, it is the address for service in India. That means the address of the attorney or the agent or the advocate in India. In brief, let's see what is the life cycle of a trademark when it comes to Indian scenario. Like any other application, first of all, you are supposed to file an application before the registry. These days, everything we are doing in online mode. Online mode, the law has also asked us to do in online mode, and to the benefit of the applicant, there is a 10% rebate, 10% waiver in fee when you choose the online mode. So why to waste your money also? You apply your online mode. In the online mode, you submit the application online using the trademark office portal. Immediately, when the payment goes through, the application number is generated, the data is entered. The application is immediately sent for a formalities check. If the application or if the image or if the logo or the mark is such that it contains some figurative element, then it is sent immediately for the Vienna codification. Vienna codification is another classification. It is governed by the Vienna Agreement. Again, as the name indicates, because it was signed in Vienna in Austria, that's how the name of the agreement is. So such classification helps in anticipation searches by the examiners, by the registrar. So once the codification is assigned, once the application passes the formalities check, an examination is conducted, technical examination. If the examiner believes that there are certain objections, then an examination report is issued to the applicant or his attorney. You are given a certain timeline. You are supposed to respond to the objections. If the objections are satisfactorily responded to, then the application would proceed to acceptance. However, if the objections are not satisfactorily met, then the registrar would provide you an opportunity of a formal hearing, whereby you would be given an opportunity to present your case before the registrar. Again, these days, because of the pandemic, most of the hearings are being conducted through video conferencing mode. If the registrar is convinced with the submissions which you have made, then the application would proceed to acceptance. If the registrar is not convinced, then he would refuse the application. Once the application gets accepted, the application is published in the Trademarks Journal. The Trademarks Journal is published every week on Monday. And once it is published in the journal, after that, it would be open for 4 months for any or third party to oppose it. If there is any party who believes that you are trying to wrongfully obtain the mark and it belongs to him, or if he is the prior user, then he would oppose it. There are opposition procedures are provided in the law. That is a separate proceeding altogether. It would start, and once the opposition proceeding gets over, either in favor of the applicant or in favor of the opponent, that would decide the fate of the applicant. And once it's registered, if there is assuming there is no opposition, and the 4 months window period of the opposition gets over, the application would be registered and you would be issued with a certificate of registration. Once the certificate of registration gets issued, the mark is valid from the date of filing till 10 years. The special feature of the trademark with respect to trademarks is that you can keep on renewing your trademark till perpetuity, till the time you believe that you want to use that particular mark. The only criteria remains that after every 10 years, you have to renew it. You have to pay. There is a certain fee provided by the law. You have to pay that fee to the trademark registry, and you can get your mark renewed and you can use your mark. There is a concept of international application, which is governed by the Madrid Protocol. Initially, India was not a signatory to this particular treaty again. But in the year 2013, India became a signatory to it. India submitted its instrument of accession to the World Intellectual Property Organization. The way in patents, we have the PCT application, that is a Patent Cooperation Treaty application, or the international application. Likewise, in the trademarks, it is the international application or the Madrid application, which we say. There are certain benefits associated when any applicant thinks of filing of an international application. With a single application, you get a window, you get registration, you get your mark registered in several designated countries. Whosoever the members or the contracting parties, whosoever or whichever are the signatories to that particular treaty, that Madrid Agreement, your application gets enforced in that particular, in all those designated contracting party automatically. the criteria which remains is that the certificate of registration would be provided by the World Intellectual Property Organization. However, the formal examination would be conducted according to national laws of each of the contracting parties. That is the only difference. And for example, if you have applied for example, if any foreign applicant has applied for international application, then India would examine the application, India would issue an examination report, and then according to the national laws, the way we have discussed the life cycle of the trademark application, similarly, the entire procedure would happen, that the examination would be scrutinized according to the trademarks law of our country, and the examination procedure would happen. And then subsequent to the successful examination of the application, that mark would be registered in India. A peculiar feature again when it comes to trademarks, that if you won't use it, if you don't use your mark, then there are chances that you would lose the rights to your trademark. Or if you're not using your mark properly, then also there are chances that you would lose your right. If you don't renew it, if you don't if you start using it in generic terms, for example, we say isko Xerox kara lana, Xerox kar do. Whereas the fact is that Xerox is a mark. We are not properly using the mark. We should say that get it copied, get a photocopy done for this particular document. Instead, we have started using the trade name, the trademark. Another example, we all have the habit of saying Google kar lo. What is that? Google is a trademark. We intend to say that conduct a search on internet. We intend to say that using the Google search platform, conduct a search. But whereas the fact is, not every time you are using the Google. Maybe you are using Bing, which is a search engine provided by Microsoft. That is not the property of Google, but we generally say Google kar lo. So that's how improper use of the mark tends to lose its essence or its worth. So if you fail to renew it, if you do not police your own mark, meaning thereby if you're not vigilant, for example, if you have purchased a piece of land, suppose a piece of land, and you do not put across a fence around it, if you do not put a boundary wall around it, then maybe, and even if you do not go to see in what condition your land is, then definitely there are quite possibility, there are chances that any third person would start freely using it because he is not aware of the fact that you are the owner. Maybe you haven't gone to see your land for say 4 years or 5 years. So there are chances. Likewise, if you do not police your own mark, then any third person would be freely using it and you would not be aware of it. So that's the reason that big companies, for example, like Coca-Cola or Nestle, they have their investigators. They keep their investigators, and their work is, their duty is to roam about in the market, and they keep on identifying the counterfeited goods. For example, you would come across say a similar kind of product like Nestle has the product Kit Kat, but you would come across at some small rural areas, you would say Kit. So what's that? That is a dilution of the mark. Or you would say find a Kit Kat written on a slipper or a footwear. So again, that is improper use of the mark. And unless and until the company is vigilant about its mark, then there are chances that people would get confused. People at small places, or people would consider that maybe, who knows, Nestle has now started its operations under the footwear domain, whereas the company has not started. So that's how the under common law we say that you either use it or you lose it. So the proper way to avoid the genericide of the trademark is to properly use it, and you need to be vigilant about your mark or your client's mark so that no third party misuses it. And the best way is to use it properly. Always, if it is a registered mark, I have already mentioned that you should use capital R within a circle in order to indicate that the mark is registered. If it's a pending, you need to use capital T and capital M somewhere adjacent to your mark. And the way you have sought protection on your mark in the similar format, in the similar style, you should always use it in order to avoid the genericide or the losing of the right over the mark. Again, another example, a few examples as to how to avoid improper use of the marks. The way we say Xerox a document, I've already mentioned this. So photocopy a document on a Xerox copier, because Xerox is a copier machine. And for that, they have sought a trademark. 2 Dells. No, it's not 2 Dells. It is 2 Dell computers, or a Kleenex. Kleenex is a, you have to use your mark followed by the noun. It's a tissue. So you need to say a Kleenex tissue. H&M, the correct is they're using the ampersand sign. They're not using and, the word and, A-N-D. They're not using that. So the correct use of the mark would help in avoiding the losing of the rights over the mark. So how can you police your mark, and how can you think of protecting it? There are watch services provided by the service providers. The advocates also keep a check on your mark if you ask them, or you can avail the watch services which they provide as a service line. Regular internet searches, these days everything is on fingertip of, we are using internet 24/7, so you need to be vigilant, you need to, and as I say, you need to use your internal eyes and ears. So that was with respect to the trademarks. If anyone has question with respect to trademarks, I would be pleased to take in another 5 minutes. Otherwise, I would proceed with the presentation on GI.
Madam, you continue GI. We will take questions on both.
Okay, fine. So there is another form of IPR, that is the geographical indications. It is a very unique kind of protection provided. Why I say unique? Because it is not an individual right. It is not provided to any company. Unlike other trademark, unlike other IPRs, the way patents can be awarded to an individual or to a company, or a trademark can be provided to an individual, a trader, or a retailer, or a company. But when it comes to GI, GI is basically a community right. It is always awarded to a group of people, to an association of people. A GI, as the full form of it is geographical indications. It is a sign which is used on goods that have a special geographical origin, meaning thereby the attributes which are passed on to the particular goods. It is because of that particular, because of the geography or the climatic conditions or the atmospheric conditions or the weather conditions of that particular area, and that quality is imparted to that particular product. For example, Kesar, the saffron from Kashmir. So the climatic conditions which prevail in the valley of Kashmir of our country, that particular climatic condition is responsible for imparting the flavor, the fragrance to the kesar or the saffron flowers. So that's what geographical indication is. The goods possess qualities or reputation which are due to that particular place of origin. It is intended to designate product quality, highlight brand identity, and preserve cultural tradition. Another main essence of the trade geographical indication and the distinguishing feature from trademark is that it helps in preserving the cultural tradition. How? We'll see in a couple of slides. So when it comes to GI, what is protected? Many times people get confused as to what they should think of protecting when it comes to GI. Let me tell you, a GI is something, a geographical indication is something for which you just cannot come up with a GI overnight. No one can think of coming up with a GI overnight. It is a community right, meaning thereby people have been using that particular, say if it is a pottery work, they have been, or if it is a weaving work, or if it is a handicraft work, then people have been making that particular handicraft or that particular pottery since generations. That particular handicraft work or the weaving work or the pottery work is being carried out in that particular locality since ages. And then the qualities which are associated with that particular work is only because of that particular region, or the weaving technology or the weaving quality which comes is only known to the people who are living in that particular community, in that particular area. So that's the reason it is a very unique kind of IPR protection. It is only given to that particular association or the community which is involved in carrying out that work. For example, the Patani weaving, or the Channapatna toys of Karnataka, or the Nizamabad black pottery, or Alfonso mangoes, or Mahabaleshwari strawberries, or Jalgaon bharit brinjal, or Solapur chaddar, or Kolhapuri chappal, or Tirupati laddus, or Agra Petha, Madhubani painting. There are several examples of GI, and if the information which I have is correct, then in our country, it is the Maharashtra state which has got the maximum GI registered in its name. That means maximum GI hails from Maharashtra in our country, if the information which I have is correct, and if the data has not changed in recent times. So what category of goods can be protected under GI? It could be either agriculture goods, handicrafts, textiles, alcoholic goods, foodstuffs, natural goods, or the manufactured goods. And the examples, as I have said, Alfonso mangoes, or Nizamabad black pottery, wine, whiskey, Bikaneri bhujia, coal, leather. So there are two types when it comes to GI. There are indications that are proper geographical names. For example, the Darjeeling tea. Darjeeling is a place and tea comes from there, so Darjeeling tea. Or indications that are traditional but non-geographical names. For example, the Basmati rice. So now the question comes to our mind as to why GI? What is the need of providing GI protection when it is such a unique kind of IP, and why should one think of integrating it as a form of IP? Why the government thought of providing protection to GI? Because the traditional knowledge also needs to be preserved. The traditional knowledge and mostly such traditional knowledge are associated with the rural areas. So it helps in the, such protection helps in the upliftment of the rural communities. It also helps them in obtaining market recognition. It helps them in obtaining a premium price for their product, for their hard work, which they invest in producing a similar, a quality product, which is not only imparted in one product. If you see, if I talk about Patani weaving, every single sari which you would see made by the weavers over there, it would have that particular level of quality associated there with, and it would, every single piece would have that particular weaving quality, and not any other person from different area won't be able to come up with similar kind of product. And even if anyone tries to come up with, or if it, again, why to negatively affect the those community, because it is their traditional knowledge. So they are the one who should be rightly benefited for their hard work. So it is often associated with non-monetary benefits also. As I have already said, it helps in protecting our traditional knowledge, and it helps in protecting the community rights. Again, the question, why GI protection? I preferred segregating it under two different categories, as the cultural benefits and the economic benefits. So when it comes to economic benefits, the higher prices would be, once a GI protection is accorded to any product, then they are able to get a niche market for their product. They are able to get a premium price for their product. They are able to attract the foreign investments. They can undergo some, they can think of setting up a company under some partnerships. They can, in a sense, they can generate employment. Again, if someone tries to steal something, some idea, some information, some technology from them, then they are able to prohibit them. They get the protection from unfair competition, plays an important role in the rural development. And foremost thing is that it helps in providing the genuineness of the product and the authentic product, availability of the authentic product in the market. When it comes to the cultural benefits, as we have already discussed, that it is a community property, so it helps in the protection of the original product, protection of the goodwill, protection of the reputation associated with that particular locality, and it is a matter of national pride. So that's the reason GI protection is accorded. Because trademarks and GI, they are interrelated in a sense. It is also provided, trademarks are also provided for the goods, geographical indications are also provided for the goods. Both the geographical indications and trademarks are governed by the classification, that is a niche classification. So because GI is only for the goods, whenever a GI application is submitted, it is submitted under any of the classes from 1 to 34 of the goods classification, which is provided under the niche classification. So let's see a quick comparison when it comes to trademark and GI. What are the differences between a trademark and a GI? Trademark could be a private monopoly right, whereas GI, it is a public collective right. It is never as awarded to any individual. It is always a community right. Trademark rights can be assigned, can be licensed to anyone, whereas a GI, it can neither be assigned to anyone nor it can be licensed to anyone. Because it is a community right, it solely belongs to that particular community which is involved in the making, in the manufacturing, in that of that particular category of good, be it textiles, foodstuffs, or the weaving, or the handicrafts, whatever it is. So for a trademark, it is possible that you come up with a logo overnight, you design something, you think of making it, and trademark provides, the law provides a provision whereby an applicant can submit the application under the category of proposed to be used, meaning thereby that the applicant has so far not started using the mark, and therefore he has applied under the category of proposed to be used. Whereas for a GI, it is not possible to come up with a GI protection overnight. It is a traditional knowledge. It is a community right, so no one can come up with a GI overnight. Trademark provides identifies the source of a product, whereas a GI, it identifies geographical origin, and certain characteristics are imparted to that particular product which is due to that particular geography, or due to that particular the climate which is prevailing, or the atmospheric condition which is prevailing in that particular geography. So again, when it comes to geographical indications, because it is a form of IPR, it is provided by the government. So there is a life cycle. Just like other form of IPR, it is also, again, you have to submit an application before the GI registry. GI registry is in Chennai. There is no other office which takes care of the GI applications. So you have to, and because these days everything is online, so the place of the registry doesn't matter. You can prepare the application and you can submit it online using the portal, which is again available on the IP India website. So you prepare the application and submit it before the GI registry. Once you submit the application, the registry conducts a formal scrutiny, and in order to see if everything is in order, you have prepared the application and you have submitted the statement of case and all other requirements which the law provides for. That formal scrutiny is done. If the examiner finds some discrepancy, then a formal notice is issued to either the applicant directly or to the GI agent or the advocate through whom the application has been submitted before the registry. So you are supposed to respond to that formal notice within 1 month of issue of that objection letter to you. Once you have successfully complied with the requirements or the objections whatsoever the examiner has raised, the examiner would take the formal scrutiny of the application. And the formal scrutiny for GI, because it is such a peculiar kind of protection, a consultative group of not more than 7 persons are formed by the registrar, and that particular association, that particular consultative group of people, not more than consisting of 7 members, they conduct the formal examination of the application. And upon examination, again, if they find some discrepancy, they would issue you the objection letter, and within the issue of the examination, within 2 months of issue of the objection letter, you are supposed to respond to it. If you do not comply with the requirements, then the examiner or the registrar would refuse the application. However, if you successfully comply with the requirements, then the application would find its acceptance. And once it is accepted, it would be advertised in the GI journal within a period of 3 months from the acceptance. Again, for the purposes of getting it opposed by any third party, if any third party's interest is being hampered, then that third party would get an opportunity of opposing your application. The opposition proceedings would again proceed according to the requirements of the law, and depending on whosoever succeeds in that particular opposition, the application would find the allowance. Another peculiar feature with respect to GI register is that GI register has got 2 sections, part A and part B. The association of people or the community whosoever has applied for the application of GI for any particular category of good, that particular community or the name of that association would find its place in part A of the register, whereas the authorized users, because see, it is a community right, and generally it comes from the rural areas. So since generations, it's happening that every other house is involved in carrying out that particular work, as I have said, the patani weaving or the Nizamabad black pottery. So if you would go to the village Nizamabad, which is a very small place in Azamgarh district of Uttar Pradesh, you would see that every other house is involved in that particular pottery work. So it's not possible for the entire village to form an association and then to apply for an application. So a group of say 15 people formed an association and they applied for the application, whereas the other people who are also equally involved in carrying out similar work, they get to apply under the category of authorized user. They need to submit an application. There is a very nominal fee of ₹10, and they can get their name registered under Part B of the GI register. This is the life cycle of the GI when it comes to a GI application. Now let's quickly see a couple of GI granted GI in our country. In the left corner, you would see a black kind of item is kept. That is Nizamabad black pottery. That is the work which Nizamabad people they carry out. Then the Kolhapuri chappal, Channapatna toys, Madhubani painting, Agra petha, Kullu shawl, Kanjivaram sari, Banarsi sari, or the handicrafts from Banaras, the glass beads from Banaras, Agra petha, Bikaneri bhujia, Tirupati laddu, Darjeeling tea, Nagpur oranges. N number of GI have got registered in our country, and if again the information which I have, it's more than 370 registered GI in our country. Definitely that 370 includes the foreign applicants, foreign GI also, but then a lot many are from our country also. So in nutshell, because it's a concluding session, it's the last session for today's webinar. And we started with the research, how the academicians can think of integrating the research with IP. So let me help you understand that it's all about the relationships and how in a single product, how you can think of coming up not only with one form of IP protection, but several different forms of IP can be integrated all together in a single product. Let me help you understand. So whenever it is with respect to a functional aspect or the mechanism, the way a product is working, the mechanism of the product, then you can think of seeking a patent protection for it. If you are thinking of seeking protection on the aesthetic appearance, the eye appealing factor of any product, the shape of the product or the appearance of the product, then you should think of applying for a design registration under the designs law. If you are trying to compete on the quality of your product or services, you should think of applying for a trademark. If the product is such that the attributes which are accorded to the product could be attributable to the location or geographical indication of that particular geographical origin of that particular product, you should think of applying for a geographical indications application. If you want a protection on literary or the artistic work, this would include the arts students or the candidates from the arts background or the fine arts or the political science or the social sciences background, or even from the software background, because in our country, patent rights are not provided on the software so far. However, copyright is provided under the literary category on the software. So you can think of the copyright protection. And if you do not want to disclose any of the information to anyone, you can keep it as a trade secret. The way the Coca-Cola company, so far they have not disclosed the formulation to anyone, and it is still as a trade secret. So this is how you can think of integrating different aspect of a particular product. For example, if I say, take an example, a rotahaler or a multi-haler, the device which is provided by the Cipla company, asthmatics would be able to clearly associate with it. So the mechanism, the way the drug is released, the moment the person who is trying to inhale that drug in his mouth clicks the button, and the mechanism, the way that particular device works, that they have got a patent protection on it. On the device, the design of the device, they have got industrial designs protection. They have kept the name multi-haler, though it is a product by the Cipla company. They have kept the name multi-haler. They have got trademark on the word multi-haler, and on the user manual, which they provide as a single page leaflet inside the box as to how you need to use the device and how you need to maintain it, how you need to keep it clean, that they have got a copyright protection on it. So as a researcher also, you should also think of integrating different forms of IP in your one single product. If you have a clarity, unless until you have a clarity on different forms of IP, you won't be able to do so. So with that idea, I use this particular slide in order to give you that insight. With this, I would end my presentation. Before I end up, I would like to give a disclaimer that several illustrations whatsoever I have used in the presentation are copyright protected, and they are merely shown for the educative purposes under the fair use doctrine, and they should not be further distributed. And as a final note, I would like to say that since I'm not your attorney, whatsoever information I have shared, that should only be considered as a general information. It should not be constituted as a legal advice. And I believe the information which I have shared, you may find them to be helpful. So thank you once again for being so patient and so patiently listening me out. Since morning, you all have been over here, and I understand that being the concluding session, it gets very taxing to remain connected. So thanks to everyone.
Yeah, thank you very much, madam, for taking us to the world of trademarks and geographical indication. And the example you cited was the example that the commodity that we use every day. So right from waking up in the morning to going to the bed. And though you are right that on online platform, it's been 4 hours since morning, but then the presentation was such a lucid presentation that the participants were glued to the screen. So on behalf of the organizers, I thank the participants also. And before we close, we take you to the question answer session, and I request Donde sir and Sathe madam to do the needful. Thank you.
Okay. Madam, my first question is related to the Myntra logo. Now the logo, the first logo is now changed, and the first logo had a tagline of "Utha Le Re Baba," and it resembled a naked woman. And then NGO activist named Naz Patel, she filed a complaint against this logo, and later on the logo was changed. Now the question is, how in the first place the logo got approval?
See, the NGO, the activists, they have filed for its cancellation. When it comes to logo, don't you think it's the eye appealing thing? Someone is looking at it, someone could see it as a naked woman. Trust me, I being a woman, I tried to analyze it 1,000 times, but I could definitely not see it as a naked woman. So
Madam,
is the perception let me complete, please.
Yeah,
It's a perception of an individual as to how do you think. And when it comes to such activism and such activists, definitely the law does not want to, or even the company won't want its monopoly to lose its monopoly, or to lose its customers for such petty things. So it's better to change the logo rather than to get into argument of dragging it into the conversation, like no, it's you cannot see it as a naked woman, because if someone is perceiving it as such, it's better not to get into arguments. So that's the reason. And if I had been the registrar, then definitely I would have also have granted, because as I mentioned, despite being a woman, I could not see it as a naked woman image, unfortunately.
Okay. But they have changed it mind. They have made a minor change, and with that change, now it is no more looking as a naked woman. Okay, but at first place when they changed the logo to new logo, and then the active was convinced that it is not no more change naked woman. Means there is no major change in the logo. Logo has kept as it is. Only
the color combination. Change. Only the color combination. They have tweaked the color combination. That's the reason I said that I tried to analyze it 1,000 times. But what is it being perceived by someone? It's definitely, why the activists at the first place, they felt it as a naked woman, and why you are also perplexed equally as to why the second logo has got acceptance by them and the first logo did not went correctly to their eyes. So these things are very debatable, and there is no concrete answer to it. So it's better to, being a company, being the right holder, they did their best, that they slightly modified it in order to convince them.
Okay, thank you, madam. My second question is it right on the part of organization from Ulhasnagar named United Sindhi Association? United Sindhi Association. They are labeling their product as made in USA. Their organization name is, it is from Ulhasnagar. All Sindhi people, they have organization called as United Sindhi Association. So if you abbreviate it, it becomes USA, and they label every product as made in USA. So is it not deception of the people?
Correct. It is very deceiving. Even if I would see, or even general people would get confused. So they are using it now, unless and until they apply for it, the registrar cannot take, or the government cannot take any action. Again, any activist group would come to take any action. Or if there are activist group in our country who represent the interest of the United States of America in our country, then definitely they would be the one who would come into, who would take an action first. And they would provide firstly a cease and desist notice, unless and until they have applied for it. If the people of Ulhasnagar, that Sindhi community, if they have applied for registration, then definitely they would, I'm very sure they won't get the registration on it.
Okay. Thank you, madam. Now over to Sathe madam for remaining questions.
Thank you, Dr. Donde sir. Madam, we had a very interesting and informative journey of trademark and GI. Very nicely presented it is. Now there are two questions from my side. First question asked by Rushali Bhalirao madam. On first, that is on trademark. Is there any class for eco-friendly products? And what are the eco marks?
Eco-friendly products, it would be, again, it's a very broad term, broad expression which she using. So eco, even if eco-friendly could be the fertilizers could be, so it would fall under the category of chemicals. If you are saying that it is the organic products are also, if you are saying organic colors, then again it's eco-friendly, so it would fall under different class. So what is the product? Eco-friendly is something which you are saying that it is not harmful to the environment. You need to eventually, that is what is a product? You need to categorize, you need to define that first. So unless and until you give me the description of that particular product, I won't be able to assign the class to it. And for assigning the class, it's a very easy thing. I have already shared the URL and the website address where you can conduct the, where you can key in the goods or the services, and the relevant class, you can get hold of the relevant class by conducting a search on that.
So there is one more question, madam, from Ratna Yadav. As indigenous people are not enough educated, can someone take it and get it registered on his or her name? This is asked especially about medicines.
Uh,
If somebody is not knowing about how to register, how to get that trademark, someone else can do that for her or
yeah, definitely. See, चोरों का तो कुछ नहीं कह सकते ना. Anyone could come and steal. So that's the reason you need to be vigilant. But then, as she has mentioned that rural people, they are not much aware of. So that's the reason there are several activist group or the NGO people come into play. And then see, there are certain, with respect to different forms of, first of all, I am not very sure which form of IPR she is talking about. If she's talking about GI, then definitely they have to present a statement of case. They have to say, they have to prove that it is that particular community which is involved in carrying out that particular weaving or that particular handicraft work. So they need to, hell lot of substantive evidences are required to be submitted, including the map of the geographical region from where they are coming. So the registry blindly does not grant everything. There is a formal scrutiny with respect to each of the IP applications. So unless until that is, they get through that, they won't be able to get protection on anyone else's rights. Secondly, every form of IPR has given a provision of opposition. So that's where the role of the such people comes when if somehow any third party tries to misuse their rights, then they need to be at least this much vigilant that they get to know, they get their opportunity to oppose it. And then there they can present their case as to how their rights are being encroached upon by any mischief.
Okay. Thank you very much, madam. Now over to Joshi sir.
Okay, thank you, madam. May I call upon Dr. D.B. Patil sir to propose vote of thanks for Nupur madam? Patil sir?
Yes, sir. Hello.
Yes, sir, you are audible.
Thank you, sir. Once again, good afternoon to all. It is my privilege to propose vote of thanks on behalf of Research Promotion Committee, IQAC management, staff, students, and guests from various organizations present for the national webinar. Madam, you have nicely justified the topic of the session 3, that is trademark and geographical indicator. I am sure that all of us are definitely benefited by the knowledge that you have imparted in this session. I am very much thankful to you, madam, for accepting our invitation and delivering such an excellent talk dealing with trademark and geographical indicator. Thank you, madam.
Thank you.
Yeah, thank you very much. Madam, I request you to be there for some time. And may I now call upon the convener of Research Promotion Committee and Vice Principal, Dr. Seema Sapre, madam, to propose vote of thanks for the entire national webinar. Over to you, Sapre, madam. Hello, Sapre, madam. Seema Sapre, madam. Please make her co-host. Vanita, madam.
One moment, sir.
Yes.
Yes, one moment, please. Sorry.
Yeah.
And the payment issue, ATKT issue. Payment of subject right? Payment of subject का एक साथ रद्द करके.
Ma'am, you are co-host now.
Sapre, madam.
Yes. Take a subject group mapping promotion. To हो जाएगा.
Thank you so much.
Promotion वाला करके.
Thank you, Joshi sir, and good afternoon to all. On behalf of IQAC and Research Promotion Committee of Kirti College, I, Dr. Seema Sapre, take this opportunity to propose formal vote of thanks to all those who have directly or indirectly contributed to this national webinar on IPR organized by us. At the outset, on behalf of the organizing committee of this webinar, I would like to extend my heartiest thanks to our honorable resource persons, Dr. Mridula Bede, Dr. Niranjan Yevle, and Advocate Nupur Goyal, We are really enlightened with their knowledge and presence. I must mention our deep sense of appreciation for their lucid presentation on this complicated and very important topic of intellectual property rights. We are thankful to our Honorable CDC Chairman, Advocate Neil Helekar, and DS management for their motivation. I would like to express our profound gratitude to our principal, Dr. D.V. Pawar, for his enthusiastic support. Also, I take the opportunity to thank our vice principals, Dr. Ravindra Kaude, Professor Vittal Sontakke, and Dr. Minal Mapuskar for their moral support and guidance. A special thanks to our dynamic IQAC coordinator, Professor Samuel Matthew, for constantly encouraging us for conducting various activities and keeping the atmosphere vibrant in this pandemic situation. I wholeheartedly thank and congratulate the organizing team for their excellent teamwork, which has made this webinar successful. And last but not the least, a big thank you to all of you for sparing time from your busy schedule and attending and actively participating in this webinar. Without you, the webinar wouldn't have been successful. I once again thank everyone for making this program successful. With these words, I hand over the mic to Professor Chandramohan Joshi, appreciating his excellent comparing. Thank you. Thank you very much.
So nice of you, madam. Thank you very much. Dear organizers, do we have a group photograph to be taken before we end the session?
Yes. Hello.
हाँ, yes sir. Principal sir. ग्रुप फोटोग्राफ लेना है. नूपुर मैडम है यहाँ पे.
तो कैमरा ऑन करना है.
हाँ, तो may I request all the co-hosts to turn on their videos, and Nupur madam, you be there also with your video.
I am here. Thank
Yeah,
you.
okay. And thank you very much for lucid presentation, madam.
Thank you. I am glad.
Mahajan sir.
I think Vanita is there. Vanita.
हाँ, वनिता मैडम, महाजन सर, मैथ्यू सर, सापड़े मैडम, साठे मैडम, दोंदे सर, प्रभा मैडम. And we also request dear participants to fill the feedback form to get your certificate, please. And that will help us to, organize and improve upon the course of action in future.
Shyam, you are going to take the.
Vanita madam, if you can.
Yeah, I will. Yeah.
Okay.
Thank you. One moment. Okay, 1, 2. Give me just one moment, just to check if it's fine. I have clicked the photograph.
Okay, thank you very much.
Thank you.
So, Pawar sir, should
Yes,
we
sir.
call it a day?
Yes, sir. Yes, sir. Thank you. Right from the 10 o'clock, I think, correct? No, not.
Yes, sir. Yes, sir.
2:30. Yeah, very good.
Okay. So thank you very much to each one, and thanks to Nupur madam once again. So on behalf of the chair, Principal Dr. D.V. Pawar sir, may I now declare that the session is over. So thank you each one for being there and being supporting.
Thank you.
Thank you, sir.
Thanks to all.
Yes, congratulations, Mahajan sir.
Congratulations, RP